where it stops, no one knows. We're going head into the unknown. Na, 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 na.
Hello, hello, hello. Happy Friday, TGIF. Welcome back to Criminality. If this is your first time here, welcome to Criminality. We are covering the post-conviction relief hearing of Todd Mullis since he was convicted in 2019 of killing his wife, Amy Mullis, with a corn rake. We are currently at the beginning of day 5. So we'll see how far we can get today. And then we have gymnastics. I'm going to go do gymnastics. My daughter has gymnastics and I get to be the driver of, I get to drive her around this weekend. So I won't probably be live over the weekend. So we'll probably end up having to do part 6 on Monday. Lacey, how was Snow White? How was Snow White? What's up, Joanna? Joanna has been on top of all the Karen Reed stuff for us. So that has been fantastic and made it very easy for me to keep up on everything going on. Hey, CH. He's going to. Yeah, I'm not doing any back bends. We won't be doing anything on Monday because I'll be in the hospital. What's up, Brian? Oh, Carla, it was good. So cute. 109 minutes, perfect. In and out. Hi, Dina. Hi, Indiana girl. What's up, Journey? What's up, Just Jen? Hi, Mav. What's good, peeps? What's good, peeps? Hey, Chelsea. Hey, Rexy. Hey, Shaz. I don't know if I missed anybody up here. Let me go see. See, I did some replay of yesterday's, and the shoelaces have me in stitches. That was about. I know people are probably like, "Oh my gosh, she's so bad." Hey, Rocky. Oh, it was so funny though. It's like perfect. It was like perfect for exactly what we were talking about. Hey, Chris. Hi, Soulshine. Hey, Laura. Okay, so we are Dina. Did I say hi to Dina? Hi, Dina. I don't know if I said hi to Dina. I don't even know. Okay, well, I'm cut off. It's already. I can't even keep track of what's going on. And it's only 8:35. Hi, Amy. All right. Anyway, let's get this party started so we can try to get through as much as I can. Tiny Human has minimum day today again. So once again, I am waiting to hear from my husband on whether he can pick him up or not. It'll depend on his, what's going on with his work. So I will keep you posted whether I have to stop or we can keep going longer as soon as he lets me know if he is available. Are you still into Hackman? I sent you a few articles the other day. I am. There was something I haven't. I should go look. I'll look and see what you sent me. I was going to say there's a couple things that I had just read. That's okay, Dina. You're worth 2 times. Yeah, I didn't get cut off. I got an official hi. Yeah, you got here on time, Hammy. You got here on time. Hi, Kathy. I am. Oh, everyone. Ho, ho, ho to everyone. It's the wrong season, Ems. Wrong season. Or you just call us all hoes up in here. Up in here. Okay, so yesterday when we left off, we were still on direct of Todd Mullis's original defense attorney from 2019. Due to scheduling purposes, he won't be back until the afternoon on this day. So they're going to be starting out with a different witness, and then we'll go back to the attorney again later in the day. How was before bros, baby? So let's get to it. Ain't nothing to it but to do it. Oh, hey. Dina's up with this witness. Why can I not get to where I want to be?
You're about to give will be true and correct.
Here we go.
The microphone is on.
Slow this down. Slow this down.
Adjust that as you need to so you can sit comfortably. Ms. Neshwa, whenever you're ready.
Good morning.
If he gets a new trial, will Tara and company be his attorneys? They can be, yeah. I believe they probably would stay his attorneys. I don't think that they would have, they may not have somebody else come in because of the fact that they obviously know the case more than anybody at this point. They've been doing it for a long time. Hi, Teresa. Hey, Law Junkie. Hose before bros, LOL. It's more like T before D. Especially the SHD. No, T before the secondhand D. Okay. This is bad. It's only Friday morning and I'm already a disaster. So.
My name is Dina Neshwat. I'm one of the attorneys for Todd Mullis. Would you please state and spell your name for the court reporter?
Yeah, Blake Heeman, BlakeHemann.
Mr. Heeman, where are you employed?
Farm Credit Services of America.
And what do you do there?
I'm currently a sales skill trainer. Previously was a crop insurance agent.
How long have you worked for Farm Credit Services?
16 years.
Farm Credit Services.
How long did you work as insuring crops for farmers?
Approximately 13 years.
So do you have a general understanding and knowledge of like planning practices?
I do.
In your, yes. Is that better?
It's interesting. What's
that better?
Relevance, I wonder.
You just said you had experience with the planting industry, farmers. Can you give me just a general idea of your interactions with them in your 13 years insuring crops for them?
Sure. The crop insurance process is pretty straightforward. I'd say the biggest requirement is understanding what coverage the producer wants. And then there's some key dates and times that need to be met throughout the year with that process to make sure that they're insured properly.
Do you recall what those key dates are?
There's several. So sales closing date is March 15th. There's some planting dates. So like corn to get full coverage should be planted by May 31st. Beans, I believe, is June 15th. Then there's some other reporting for production in as well. So.
And those are required dates?
Well, he's crop insurance. So he's like, if you want full coverage on that corn, you better have that shit planted so that it's knee high by the 4th of July.
Correct.
Is there a window of time planters have to have all of their information submitted?
Yeah, so like acreage reporting, July 15th is the deadline to have that reported.
Who is that required by?
USDA along with the AIPs, the crop insurance agencies.
Yeah.
Are you familiar with the Mullis family?
I am.
Are you familiar with their farming operations?
I am.
Who in the Mullis family are you familiar with?
All of them, the whole family. Todd, I'm familiar with Amy, Pat, all of the whole operation. Mike, Leroy.
And Leroy is the father of the three males that you just mentioned?
Correct.
And you said Amy also, Amy Mullis?
Yep.
And you insured crops and farmlands for those members of the family as well in their farming operations?
Correct.
Okay. Mr. Heeman, can you explain what an acreage farm book is and its purpose?
Yeah. Do you have that example? Or,
Yeah. Because that's
I'm
what
going
I
to do
need
that in
to
a
know.
moment, but just generally.
Generally speaking, when the producer comes to us and says, I planted this crop on this day, we map that for them to get it in the system to essentially certify those dates, crops, locations for them.
And this, is it a farm book or a frame book? Forgive me.
I know they're referred to by some maybe as a frame book. We call it an acreage report.
Okay. Is this something that's generally prepared, you prepare for each of your
Did you have an
farmers?
affair with Amy?
Correct.
Is that annually you prepare?
Correct. Annually.
Did you prepare an acreage farm book for Patrick Mullis?
I did.
I'm sorry, Patrick and Judy Mullis.
I did.
That's brother and sister.
Do you know what information was included in that acreage book for Patrick and Judy Mullis in 2018, just generally?
Yeah. Acres, type of crop planted, and the plant date, along with PAT certification that everything was correct.
I'm going to show you, Mr. Heeman, a redacted report. It's Exhibit 378. And Your Honor, redacted is just the privacy, personal data, phone numbers, social security. A 2018 acreage framework. Do you see that in front of you?
I don't.
Imagine like going to a party with this guy and they're like, so, like, what do you do for a living? And he's like, like all that veg that you eat. Yeah, I insure that shit and make sure that the acreage counts are correct. I'm a good time. I am a good time. They need to clean up their work area.
I'm going to give you my copy.
Okay.
A moment. Can you put up on the screen for me?
I think Todd does the following. Yeah.
Your Honor, the court previously received a copy of this on its hard drive if the court needs to see it.
I'm able to access it. Thank you.
Thank you, Your Honor.
My chat first.
I'm familiar with this book.
Because you created that book to put it
Correct.
together.
Yep.
What year does this acreage report cover?
This one says 2019. I'm sorry, 2018.
So just to confirm.
He kind of looks like Deacon from SWAT. I don't know if you guys watch SWAT, but that's who he kind of reminds me of. This is essentially, I can already tell where this is going. This is just to show that he had a shit ton of farmland. He had insured a shit ton of crops. And if he was not working in the field during the spring months, essentially, 12 to 24 hours a day, he could have lost his crops. So he was not at home, hanging out on the iPad, searching for weird shit.
The one in front of you covers his report.
2018.
2018, is that what you said?
Correct.
Do you know when it was prepared?
Should say on here. This was done on June 12th.
And you said the information is required to be submitted by June 15th?
July 15th.
Okay.
This copy was created on June 12th. I don't know, the copy that I had seen before had a signature on it. This one does not. So there's a chance that we did it before June 12th as well.
Okay. What page?
What's she looking at? What's she looking at over here? Oh, is she looking at the same exhibit? Okay. So this is what his insurance paper
22.
was.
Do you see a signature on that page?
Oh, yeah.
Redacted signature.
He didn't have he had no Wi-Fi.
So on the actual acreage,
He had no Wi-Fi in those months. He didn't have Wi-Fi on the iPad or connected to data until October. I want to say 18th, but it doesn't really matter because it was still October. So during those months of those searches, the iPad, whether it was on the tractor with him or not, he wouldn't have been able to search. The judge is scrolling Facebook, October 12th. Thank you. No, I was like, what is that yellow thing on? Like, what is she looking at? And then I realized, oh, that's like a map. It just took me a minute.
report, this would be a signature area where we would need a signature. If you're referring to the other 578s. Is that
Is that
one
the
you're looking
form?
at? That's a different signature.
What page would that be on?
I don't see page numbers.
He is playing Farmville. We all are, though.
I can't
like
give you a
the long
PDF
game.
number, so hang on one moment, please.
I see these. His job was just so boring.
We're going to show you
Sure.
with the court's permission.
Certainly.
Of the electronic document.
Yeah, so that document right there is the certification from the Farm Service Agency. And so that signature would have been the date that Pat certified those acres with the FSA office or Farm Service Agency, which is separate from our acreage report.
Okay. Mr. Heeman, so again, in this report, is there mapping information in there regarding fields that the farmer would own or be affiliated with in renting, for example?
I'm going to object. One, I don't know if we're admitting this exhibit. The state certainly objects to the admission of the exhibit. So right now it's assuming facts, not in evidence. I'm also going to object because it's irrelevant. It's not Mr. Mullis' farm specifically. So under those grounds, as well as 5403 prejudice, as it would be misleading.
Do you wish to respond?
Yes, Your Honor. I'm not asking for specific information. I'm asking generally, are there mapping, what is included in that report, just generally speaking, and there will be foundation in just a few more questions. And it's certainly relevant because it gives information to support that certain allegations by the state or testimony in the underlying trial by the state is false. And we'd like to show that with this, what the court is about to see.
Well, I mean, at this point, I guess I don't have any information to tell me what these maps or this information has to do with Todd Mullis. Maybe we could lay that foundation and then move forward with the specific information about this exhibit.
Well, it depends, Kate. It depends on what farm he was working on because they own acreage, or I should say lease acreage, on multiple different properties, not just the farm, not just the Mullis farm. So that depends. But I think the whole point is that they were trying to say that they were in the middle of the night, and now we're being shown that they were actually during times of the day that he wouldn't have been home. So I may have missed this or not, but was there any direct evidence in this case, or was it all circumstantial? It was all circumstantial, which is not a bad thing. Circumstantial cases are very, very common. Direct evidence is essentially a witness who saw exactly what happened, which is terrible anyway. We all know witness testimony sucks. Any type of videotape or anything along those lines, like recordings, that's all direct evidence. Confessions are considered direct evidence in most places. So circumstantial is actually, people don't think it's as beneficial necessarily, but I think it's actually probably more, because all your DNA and everything that people want were, all the things that people actually want, like DNA, hair, all that kind of stuff, all the that's all considered circumstantial evidence. Of course, Indiana girl.
And a few more questions, I think I can establish that.
Sure, why don't we
Yes.
go there and then we can come back to the exhibit?
Sure.
Okay.
Okay. Foundation.
Problem is, it's like you don't have DNA of your husband anywhere near you. You have no room,
Do you know who operated the planter for the Mullis family members' fields that you insured the crops for, from your understanding?
From conversations, I was aware.
Objection, hearsay and speculation, Your Honor.
Overruled.
You can answer.
Okay. From conversations with the Mullises, there was an understanding that Todd operated the planting equipment on occasion.
Did you have any reason to believe that that information wasn't true?
No.
You actually insured fields for Todd and Amy Mullis in their farming operation, is that right?
Correct.
No, a corn rake is curved. The
Do
pitchfork
you know if
has
Farm
straight
Credit
bumps.
still insures Todd and Amy Mullis's, their property that was insured in 2018?
As
Is it
far
still
as I'm
insured
aware,
today?
Yes.
Can you say that again?
As far as I'm aware, yes.
And
There
also
we go.
Pat and Judy Mullis's property, is that,
Yeah, I'm not in that role anymore, but as far as I'm aware, yes, we do.
in 2018, have you ever met Todd and Amy Mullis before in person?
Yes, on their farm.
Do you know what year that was?
At 2018, around that time frame, probably more than one occasion.
Okay. Can you just, what was the situation, where did you meet them? What were they doing?
In some cases, it would have been signing acreage reporting documents or other crop insurance documents or deciding what coverage to take. In other instances, just on the farm, stopping in to say hi, see how things were going.
So you saw Amy and Todd Mullis together?
On one occasion, both of them together, yeah, that I can think of.
Okay. Did you notice anything unusual about them together, demeanors?
No.
Odd? Have you ever seen Todd working on a planter or fixing a planter in front of his shop anywhere or on the farm?
On that occasion that I was just speaking of, I mean, when we stopped in, I remember the planter equipment being there. Is about this time of the year. Seems like Todd was working on the equipment again in his yard in front of his shop.
Okay. Okay, Your Honor, I'm going to go back to the showing Mr. Heeman a copy of the redacted report, if that's okay.
I think the biggest thing about the search is, Kate, she'll make the decision. That's it. It's a bench trial. It's just up to her. I think the biggest thing about the searches is Hemisath testifying at the trial that every search was done on the iPad and every search is done under Todd's Google account. Therefore, Todd did every search. There's no way to prove whether Todd did or did not do those searches. There are ways to try to prove it, which is what this post-conviction relief hearing is about, is his attorneys showing ineffective counsel from his defense attorney that he did nothing to try to prove Todd's innocence or to show the court that there was alternate reasons or that it was impossible for Todd to have made the searches. So this isn't necessarily, we're not looking at this as like a guilt or a not guilt, like we do a lot of trials we watch. So I think you also have to watch it with that in mind. We're watching it with, is this judge going to be able to decide that his attorney really did a terrible job and he's now in prison for the rest of his life based on two factors. One, the prosecution and law enforcement, I don't want to say lied, but definitely gave false testimony. And then, second, that he didn't bring in any experts to show that the state was wrong. He did not do anything to prove where Todd was at the times, where the iPad was at the times. Doesn't talk to the kids to find out if they did the searches. Doesn't find out, doesn't track Todd's phone to see where Todd was versus where the iPad was. So he does nothing to try to essentially do it. So you have the state actors saying, Todd, that's another, so there's another little side component because Iowa, you don't have to have any Daubert to be considered an expert. Like you're an expert. So when you have like Hemisath taking the stand, who's for essentially pretending to be an expert on this Google stuff, which he's absolutely not, because he was wrong on so many levels. Then you have a defense attorney that is not actually bringing anybody in that is an expert, or that even he even had look at the information to say anything. So that's kind of where we're at. It's been proven now, 6 years later, that Amy's phone had Todd's Gmail account connected to it. So searches done on her phone would show up under that Google search warrant that Hemesath took as gospel and said it was all from the iPad. So the whole purpose here is not whether you necessarily even think he's innocent or guilty, it's whether you think he deserves a new trial, and for this judge to vacate his previous verdict. That's so it's kind of funky, because you're not really looking at it. All the burden of proof here is on Todd and Todd's attorneys. The state is actually essentially on the defense side right now. So it's just kind of wonky to people who like to watch trials are typically like, okay, innocent, guilty, state versus defense. And this one's kind of a little bit backwards. So just some clarification on things. Oh, I gotta do a freaking Karen Reed live, because that case is just Brennan is such a douche. I mean, him and fucking Deputy Doofus over here in Iowa, they might be siblings. No. So, but she used her own Gmail. So that's the Gmail, like her email. That email, she had two for herself. That email she created that summer just to talk to Jerry, but that wasn't her account that she was attached to her phone. And then she had her own email, and then that was another. So layers and layers. Nobody determined whether the devices were synced or his Google account was synced, so that any search she did on her phone could have been synced to the iPad. But they never bothered, the defense never bothered to look at that. The prosecution never bothered to look at that. Nobody cared to look at that, because the prosecution just thought it's all the same. Yeah, through her email, her Gmail email. I don't know if it's going to get kind of confusing, because I don't know what kind of phone she had. He had a flip phone. Did she have an iPhone? I don't know if she had an iPhone. Todd did not. I can tell you that. He had the iPad, but. So the wedding dresses and rings could either have been made from her phone, but attached to the account signed in. I don't know the best way to kind of show you this. Okay. So, okay, here. This is what it looks like on the back end. So on my computer, you can see up here, this is my StreamYard account. You see what I mean? Now here, this is my Google account. So I'm signed into my entire computer right now under this account. You can see my little icon up here, right? Now I can switch it, and I can sign into all these other accounts. It will, if I sign into one of these, it will not change my StreamYard sign in. So for example, I will show you, okay, like my Gmail. So I can come in here and be in my Gmail account, right? Here's my Gmail under this. I can switch my Gmail account to my other account. Here, see, now I'm in my other Gmail account, my personal Gmail account. And up here, you see, I'm still signed in to the same Google account, even though I'm under a different email account. You see what I'm saying? I'm hoping this makes sense. The main sign-in for my Google account, no matter what email I'm in or what tab I have open here, it doesn't change. If I go to Google now and I type in here Google, it's going to be under this Gmail account. nothing to do with my Gmail email. I'm hoping that makes sense, because this is how I sign into everything I have open on my computer is done under the background of this main Google account, which all those searches came up on. Now, if I go and sign in on my phone under this same Google account, because that's the big thing, it's the Google account versus the Gmail. This same Google account, it's registered to my email, and everything that I search from here will show up on my phone because the account is synced to no matter what device I join from, it's going to show up from this main account. Now, if I sign in, into, this is like my son's account. If I sign into my son's account and I do searches from my computer, it's all going to show up on his laptop, and it's going to show up on his phone under his Google account. I'm hoping that helps somewhat. Does that help at all? All right, let's get rid of this. Okay, now my StreamYard's all wonky. And my chat's gone. There we go. Okay. Okay. Okay, there's my chat. I'm like, I couldn't see anything you guys were saying. My wedding dress, but I bet wedding shit was the daughter. I don't know. She was like 9. No, maybe she was 10 at the time. I still think it was her because she's telling her friend she's going to go marry Jerry. But I don't know. She was like 9 or 10. I mean, I guess maybe some young girls are some young girls are like planning their wedding. I just wasn't one of them, so it kind of just seems weird to me. Okay. Yeah, the alt T. There's multiple T's. Be careful. If he wanted to kill her, do you know how many ways a farmer can kill you? I just think that he would have waited and fed her to the piggies, but that's me and my morbidness. So alternate T. That's funny. Yeah, that was the alternate T. Yes, makes sense, even though I'm technically challenged. I am super technically challenged. But once somebody can teach me and I can do it like a few times, then I can get it. It's just like, you know, what is that? Like teach an old dog new tricks kind of thing. My iPhone is connected to my Mac and iPad. What I do with my phone goes to both. Yeah. Are you a farmer? We have other farmers in here too. That's fun. That's interesting when you have like people who actually do the work, you know. I never wanted to get married and I've done it 4 times. I never wanted to get married and I've only done it once. Passenger. You bet you. Okay, so let's go back to Deacon over here. Mr. Farm Insurance.
You can, I guess we'll have to see what the questions are.
Management report. It's no problem. He has it in.
You have it in front of you?
The paper copy?
Mr. Heeman, this book, again, you prepare for your farmers annually, is that right?
Correct.
About how many farmers or is it farmers or producers that you call them? Either.
Yeah.
How many of those did you have at the time you were working in this capacity as a...
Objection, relevance.
Overruled. You can answer.
90, I would guess, somewhere in that ballpark.
So did you create one of these books in the ordinary course of business for your farmers?
Yes.
Your Honor, we'd offer Exhibit 373, the frame book, for...
I'll do better. I'm a gardener.
Mr. Heeman, just to clarify, was this book created in the ordinary course of business
are your flowers insured? Because if not, I don't think it does. But if you have enough, if you got enough in your garden to insure that shit, I think you're good. You're golden.
As your standard practices for your farmers?
Yes.
Oh, wait.
Your Honor, the applicant would now offer Exhibit 378, sorry, into evidence.
Any objection?
Yes, Your Honor. For the same grounds, it would be misleading. It's more prejudicial than probative under 5403. This is Pat Mullis's farming record, so it's irrelevant to this proceeding and doesn't speak to Todd Mullis's planting habits or even whether or not he was the one planting, even based on the foundational testimony of the witness here. So it is more prejudicial than probative and irrelevant to this proceeding and immaterial.
Again, I guess all I've heard to connect it to Todd Mullis is that on occasion he operated the planter that I guess potentially planted the crops that would be referenced in this report. So I agree, it's way too tenuous at this point. It's not going to be admitted at this point. If you want to continue to lay some foundation, you certainly can.
Mr. Heeman, between the family Mullis, the Mullis family members, there was Mike, Leroy, Pat, Todd, and Amy Mullis. You insured their fields?
Correct.
From your knowledge of all of those fields that are insured, crops are insured, was it that Todd Mullis was the one that operated the planter for those fields?
The primary operator of that equipment, again, through conversations, was
Objection,
always that.
hearsay and speculative, and it's leading, Your Honor.
Overruled.
In those conversations, it was often talked about that Todd was the operator of the planter equipment.
Do you have any reason to
It
believe?
also testified to in the first trial, so I don't know why they wouldn't be able to do it through this witness, but they could get that in again, based on the testimony from the first trial.
That he was not the operator of the planter?
Objection, Your Honor. Again, we're just speaking to another farm book. It's completely irrelevant to this proceeding and speculative at this point. If you would like me to voir dire the witness and ask if he has specific knowledge about specific instances, I'm happy to do that. But it is speculative here because it's trying to say it's action in conformity with another document that hasn't been admitted.
You may voir dire the witness if you like.
Thank you. Good morning, Mr. Heeman.
Good morning.
You mentioned previously that you insured all of the Mullis family farms. Is that fair?
Correct.
On any specific date and time, were you present when Todd Mullis was planting?
Not to my knowledge.
Can you name any specific date or time as it relates to when he would have engaged in planting on any one of the Mullis farms, specific timeframes?
That I witnessed?
Yes.
No.
So is the full value of your ability to speak to whether or not he planted in his fields or in another Mullis family field based on what you've heard and what has simply been relayed to you?
That would be correct.
Your Honor, the state would object on the same grounds.
Again, 378 is not going to be admitted at this time.
One moment, Your Honor.
Well, they can't get in what they want to get in, so it probably becomes not useful. They're just trying to show that Todd would have been out in the fields during the time of the searches. That's really it, and they're not able to get that in because this guy has no firsthand knowledge of the fact that Todd would have actually been in the fields. Legally trying to figure out how to do a workaround. I want to ask him if they could get it in. What foundational questions can they lay to have this guy testify that Todd would have been out in the field at that time?
You said you're familiar generally with farming, planting industry. Have you ever ridden in a tractor before that's pulling a planter?
Objection, relevance.
Overruled.
Yes.
Generally speaking, do you know how fast a planter moves in the field or tractor moves in the field?
Depending on the equipment, it's probably average 5 miles an hour. I would assume would be a good estimate.
Okay. Does the size of the planter impact planting time?
Sure.
How about the shape of the field? Does that affect planting time?
Yes, I mean, a square field that's flat is going to plant easier and faster than one that's got waterways or point rows in it.
I don't, Brian. That's a good question, though. You could have been in the field. You could have been inside on his iPad. It's not too far away. I think that's the whole point, though. Is that,
Do you know if,
once again, in the first trial, they testified that it was him. It had to be him. There's no other option but for it to have been him. That was Hemesath's testimony. And then the defense tried to say, like, well, did you compare this? And did you compare that? And did you do this? And did you do that? And Hemesath was like, no, I don't need to, because that iPad belongs to him. The Gmail account is connected to the iPad and it's Todd's. And therefore, Todd did the searches because it wouldn't be anybody else doing the searches. And then he finally concedes at this trial or at this hearing that, yeah, I guess, I mean, it could have been somebody else. It could have been somebody else.
do you know the size of the planter that Todd Mullis used when he planted his own fields?
No.
So you don't know if it was a 16 rows, 24 rows?
I'm not familiar with what size it was.
I don't mean to put you on the spot, but do you by any chance, because you're insuring the fields, know how many feet are in an acre?
I should know that.
Okay, you do?
I should know that. I'm sure I knew it at one point. So the answer would be no. Not today.
Yeah, he said it's possible, but not probable.
It's the information generally that is provided in the books that you created.
Possible, but
Is
not
that reported to the FSA? Is that what it was?
He's not going to be able to get it.
This information in our books, that when we do our crop insurance reporting, our acreage reporting, we're submitting that information to the approved insurance provider, who is essentially the underlying reinsurer, so the company that's holding the insurance.
This is not. No.
Without looking
Yes,
at
I
the book in front of
disagree.
you, do you know the areas of the fields that you insured for several years for Pat and Judy Mullis?
Objection, relevance.
But this guy's testimony is not going to help
I'm
anybody.
familiar with them, yes.
Do you know the radius between, I'm sorry, ask a different question. How many fields, if you know, without looking at the book, did you insure for Pat and Judy Mullis?
Yeah, ballpark 7, I'm going to guess.
Do you know the radius between those fields?
I would say all within 20 miles of one another.
Okay. When someone is planting, do they need to refill whichever crop they're planting with certain items? For example, fertilizer or?
Yes, the seed, fertilizer, some chemical.
How
Now
often
he's asking
does
him this
a
about
planter break down, so to speak?
According to the producers I talked to, too much. They have the wear and tear affects them. They do break down, I would say, often.
What do you think he lied about? I'm curious. I don't know any factual thing that he lied about. So, I mean, I could be wrong. I don't know of him lying on the stand.
One last point. You said it was 2018 that you had met Todd and Amy Mullis,
As far as I can recall, yes.
and at one point you saw them together,
Yes.
and you didn't notice anything odd or about their demeanor or relationship.
No.
Okay. Yeah.
Just for anybody who's curious, Soulshine is going to let us know that it was 43,560 square feet in an acre. And that's what Kate. You might be right there. You might be right there. He probably did do it on his own. He probably did. Oh, you got me there. Asked my husband and he did not know off the top of his head I was testing him. He couldn't remember. So much like static and background noise in this courtroom. It kind of sucks. I think that they've really missed their mark here with this witness and Google witness.
I have nothing further, Your Honor.
Cross-examination, Mr. Gooden?
Briefly, Your Honor. Good morning again, Mr. Heeman. You manage the insurance policies or services for the Mullis family for a number of years. Is that fair?
Correct.
And your agency has done this since at least 2018, right?
Correct.
Up to the present?
As far as I know, correct.
And based on your testimony, you first met Todd and Amy Mullis personally in 2018?
Objection, Your Honor, that's not what he said.
Overruled.
That is what he said.
Is that correct?
First met them. I believe that's when I took those policies back over. Correct.
And so any paperwork that would have gone through your agency would have been signed by them on their property?
Can you clarify with any paperwork?
When you had them sign or certify the farm paperwork at issue, or that is relevant to your agency, would that typically be done on their property?
Not always.
Did you meet Todd and Amy Mullis on their land specifically, though?
On occasion, yes.
And on the number of occasions that you interacted with them, it would have been on their land?
Generally, I would say probably more often than in the office, if that's what you're asking.
And today, you can't say whether or not Todd Mullis engaged in any planting for a family member, can you? On a specific date in time?
Not that I witnessed personally.
Were you asked to sign an affidavit in this case?
Yes,
Did you sign an affidavit in this case?
I did not.
Why not?
Because the affidavit asked the same question you just asked me, to essentially say that I saw or knew of Todd planting every acre on a specific date.
And you couldn't do that, could you?
I can't.
Ooh.
To the present, does your agency still manage the farm insurance policies for the Todd and Amy Mullis land?
As far as I know, yes.
And as far as you know, that land still is placed within the Todd and Amy Mullis Living Revocable Trust or within their names, correct?
Objection, Your Honor. How would he have that information?
Overruled. The witness can answer if he knows.
I don't know the answer to that, of what it's insured under or who.
That's so bad.
So from what I've gathered from your testimony, you knew or believed that Todd Mullis would on occasion assist with planting in his family's fields. Is that correct?
Objection, Your Honor. He didn't say on occasion.
Well, the first time he did use the word on occasion. So the objection is going to be overruled. The witness can answer.
And I can clarify that. So I should clarify, as far as I knew and was told, Todd did the planting of all crops for the Mullises in the past and up to that point.
But that was all based on what you heard from other people, wasn't it?
My conversations with the Mullises.
So it was self-reported.
Correct.
And to date, you've never witnessed that, right?
I cannot recall a time when I witnessed Todd in the planter tractor on a specific field. No.
Oh, Mike Mullis.
And even the information that's included as to what date it's planting occurred in any specific year or time frame is self-reported. Is that fair?
It is.
So you aren't cross-verifying that information, right?
Correct. No.
Nor are you certifying that information yourself, right?
We take producers' word for it. They're certifying that that's accurate. Yeah.
I don't have anything else, Your Honor.
Not sure, MB. I'm waiting to hear from my husband on whether he can pick up the tiny human for a minimum day. If he can, then we'll be here and get to the attorney. If he can't, then I'll have to hop off and go get the boys. I think if they had called Mike Mullis, the brother, or Pat Mullis, the brother, or even Leroy, the dad, and said, hey, who did the planting on all of your farms? They'd say Todd did until 2019. We didn't do the planting. Todd did it. And then bring this guy up and say, okay, hey, you insured all of this stuff. What does that mean? Knee high by the 4th of July. You know what I'm saying? Like, they should have, I think that this would have gone over better if they weren't trying to get this information in through this witness. I try to, Indiana girl. I try to. He does. He's a good daddy. I got no complaints on him being a good daddy. Pain in the ass husband sometimes, but he's a good dad.
Redirect. Yes, Ron, just a couple, please.
Yeah.
Mr. Heeman, if you were to look at Pat Mullis's acreage book, would you be able to determine the fields that were planted in 2018?
Yes.
Objection, Your Honor. Again, we're referring to facts potentially not in evidence, and that has already been deemed or excluded by the court.
Objections overruled. The answer will remain in the record.
The information about Todd Mullis planting for the rest of his siblings and the Mullis family's members planting operations, did you have any reason to believe that that information was untrue?
I should have put her or one of the brothers on the stand first. And none of this line of questioning would even matter.
The farmers or producers, you said you take their word for it.
Objection, leading.
He just said that.
Well, is there?
I'll withdraw it, Your Honor. The information that they're providing to you is to get insurance on their crops. Is that correct?
Correct.
Would you say that planting and crops and the yield returned are their livelihood?
That's specific to crop insurance. It's the way they manage risk to ensure they can, again, continue to run their operation.
So they would have every reason to report it accurately. Do you
Objection.
agree?
That's a credibility call and leading, Your Honor.
It is leading. Sustained.
Mr. Heeman. I have no further questions, Your Honor.
Any requests?
No, Your Honor.
Thank you, Mr. Heeman. You may step down.
What a waste.
Sure.
It wasn't them. It could have been important. They just didn't get it in correctly, and that's my opinion. It could have been important. All they were trying to do was show that Todd would have been planting during the time of the Google searches, and that he wouldn't have been even around an iPad. And if the iPad was with him on the tractor, it didn't have a data plan connected, so he wouldn't have been able to use it.
Further evidence on behalf of the applicant.
Your Honor, it might make sense for the parties to confer with the court briefly about scheduling from here.
Okay, let's
Oh, no.
go ahead. We'll go off the record, take a short break.
I don't know about that. That doesn't really make a lot of sense. Unless it's about that same situation, I wouldn't say that it publicly discloses everything. But okay, now we're off the record already. Okay.
Of confirming. All right, we'll go back on the record here just briefly for the purpose of confirming our off-the-record conversation. We've actually been doing remarkably well, I would say, in terms of witness availability. But it's my understanding that at this point, we do have at least a
Yeah.
couple of hours before our next witness is available. And we'll be waiting until 1 before the applicant's next witness. Is that correct, counsel?
Yes, Your Honor.
Okay, and at
yeah.
that point, we'll pick back up with the rest of Mr. Firehelm's testimony, and he will actually be appearing by Zoom. Is that the plan?
Yes, Your Honor.
All right. We'll plan on that then. Counsel, I know we have a few things that we can take care of, and you will be working on some other details as well off the record, but we'll plan on resuming in the courtroom on the record at 1 p.m. Anything else
I
that
didn't know
we
we
need
had
to
such a big
address
lapse in the day.
by way of housekeeping matters? Anything on behalf of the applicant?
No, Your Honor.
Okay, anything on behalf of the state?
No, Your Honor.
All right, I'll be back in chambers then at whatever point you'd like to address the details that we need to take care of. Thank you. Court's in recess. So if you need to move, but hopefully again. All right, would you try it again for me, please?
Yes, Your Honor.
All right, that's much better. Perfect. Okay, counsel, I think we're picking back up with Mr. Firehelm's testimony. Is that correct? Yes. All right, Mr. Firehelm, I will just swear you in again quickly since it's a new day. If you'd raise your hand. Do you swear the testimony you're about to give will be true and correct?
Yes, Your Honor.
All right, and I know that the camera angle is not the greatest, but hopefully you can see counsel well enough. Counsel, if you need to move or adjust yourself in the courtroom, please feel free to do so.
Thank you, Your Honor.
Me too.
Thanks for coming back today, Mr. Firehelm. We appreciate it. I wanted to.
It's not just for the simple fact that I think he has, even if she doesn't vacate it and just throw it all away and say, hey, you state you're done, even if he just gets a new trial, that he has a defense team that can actually, provide a defense for him. Oh, heck yeah, Dan. Like, this is one of those cases that's just stayed with me since it happened. You just get those cases that you can't let go of. This is just one of those for me.
Pick back up discussing the discovery that you were tendered before Mr. Mullis's trial. Do you recall if that discovery included audio trial? Discussing today, Mr. Firehelm, we appreciate it.
I was too busy looking at the weird angle that they have this Zoom on. Okay, let me start that again.
I wanted to pick back up discussing the discovery that you were tendered before Mr. Mullis's trial. Do you recall if that discovery included audio and video files?
I believe it did. I'm not 100% sure.
Mr. Firehelm, for some reason we lost your video. I'm not sure. There you're back. Okay.
He did it on purpose. You can see him actually looking at yeah, I think you're probably going to be one of the very few in here, Kate, that thinks that. I don't think anybody else thinks that. So just an FYI, you guys, I know it's okay for people to have different opinions, so don't go picking on Kate for her opinion.
Recall specifically audio and video of an interview with your client, Todd Mullis, November 16th, 2018?
Heard by it.
If that was the interview by DCI, I believe he was at the law enforcement center. Yes, I do.
Do you recall reviewing one of Tristan Mullis done by DCI, November 16th, 2018?
He was.
I think so, yes.
Yesterday.
And are you familiar with investigative techniques such as the Reed technique?
Yes, I am.
Oh, jeez.
And is it your understanding that the Reed technique is designed to obtain a confession from a suspect?
I believe so, yes. That's my reading of it.
Did you consider or investigate whether the DCI agents were utilizing such techniques on Todd Mullis and Tristan Mullis?
I didn't match up their technique with the Reed technique, although I've seen DCI use it pretty consistently.
And Your Honor, I'm going to object on this point solely for the fact that evidence already within the record has testimony that's been uncontroverted essentially at this point. As Special Agent Turbot testified, he did not use the Reed technique, if I remember correctly.
Overruled.
Mr. Firehelm, I think my question really is that you had some education or knowledge about interrogation techniques at the time you represented Mr. Mullis?
That's correct.
And did you take
Hey, you know,
any
if that was the
actions?
case, it wouldn't be first-degree murder. So it'd still be the wrong charge. If that was what the state could prove, even if the state could prove that, they convicted him under the wrong charge, they charged him with the wrong thing. So then you are in agreement that he should get a new trial.
Or conduct any investigation to have those interviews reviewed by somebody more knowledgeable than you?
No,
Could you have consulted an expert regarding coercive interviewing techniques?
yes, yeah, they're expert for everything.
That's an expert for everything.
Did you consider
He spoke like 3 times.
investigating or locating any witnesses that could testify to Todd's good character?
Oh, character witness. He had his brother up there.
I didn't. Bob had a lot more contact with local people and family than I did.
Great, thank you.
But you guys only called the brother.
I know yesterday we talked a little bit about the 911 call that the state played during trial. Do you remember that discussion?
Yes,
Do you recall if you listened to it before trial?
yes, I'm certain I did.
And then do you recall ever playing it for Mr. Mullis?
No, that's true, Rocky.
I do not recall doing that, no.
During Mr. Mullis's cross-examination, did you consider objecting to the mischaracterization by the prosecutor that Todd was alone at the time of those purported statements?
No, I don't think so.
Did you investigate the timing of the purported statements in order to contradict that state's argument?
Max push force
Are
was
you referring to
138.
the cross-examination questions or that claim by the prosecutor that he was whispering something to her? Is that what you're referring to?
Yes.
That wasn't an issue. There was no warning about that at all until it happened.
And so you weren't able to look into the timing of those statements?
No,
If you had had notice of those statements, could you have done some investigation to learn whether another deputy or another person was on scene at that time?
well, I think it was pretty clear there was another deputy on scene. There was back and forth between Todd and the deputy before that allegedly happened.
Okay, and you didn't point that out during trial?
Again, it came up right there at the end in almost the last question she asked him or presented it to him. So no, I didn't.
Thank you. I want to move on now. Do you remember the name of a witness, Tom Krogman?
Yes, I think so. Yeah.
Do you recall there being a DCI interview that included audio?
I don't. I'm not saying there wasn't. I just don't recall it right now.
Do you recall in your review of the discovery, DCI agents telling witnesses that the medical examiner's opinion was gospel?
I don't remember that being said.
Did you consider calling Mr. Krogman as a witness at trial regarding his observations during the emergency medical services on the side of the road or his observations at the hospital?
I don't think so, no.
Do you recall an email between you and Mr. Sabers about whether you should call Mr. Krogman?
Not specifically, no.
Just a moment, Your Honor. I think I'd like to refresh the witness's recollection, but between the Zoom and the sharing, I need just a moment here.
Okay, just let us know when you're ready, please.
Your Honor, at this time, we'd like to share our screen to show an email to Mr. Firehome, but we're not seeking to admit it. It's just to refresh his recollection.
Okay, is this something that has been marked as an exhibit that we can refer to for the record, or?
It is not, Your Honor.
All right, counsel, are you aware of what's being displayed to the witness?
Yes, Your Honor.
All right, go ahead.
For the record, Your Honor, I think our next number is 977. Mr. Firehome, can you see that?
Yes.
If you would just review it and let us know when we can take it down.
You silly goose. No updates on Ellen Greenberg.
Okay.
So did Mr. Sabers and you discuss calling Mr. Krogman as a witness for Todd?
That was September 13th, I think. There was such a flurry of emails going back and forth, and I don't specifically recall that one, but I do now remember Bob bringing that up, and I don't know if we talked on the phone or just traded the emails about it.
And that would have been right before the trial started. Is that your recollection?
Yeah, just a few days before.
No, you haven't really missed anything.
Okay. I want to move on a little bit here and ask, are you familiar with the field of biomechanical
Probably.
engineering?
No, he doesn't testify.
Do
I
you
know
know?
what it is, but
I'm sorry.
I'm sorry I interrupted you. I know what it is, but I'm certainly not an expert or now that knowledgeable in it.
Did you consider consulting an expert in biomechanical engineering to investigate whether Amy could have sustained her injuries in a fall?
No.
Did you consider or investigate the principles of force that could be generated from a fall versus a strike or a swing of the rake?
I did not.
I want to show you Exhibit 233, which we looked at yesterday. It's a letter from Mr. Mullis to you. I understand it.
I think a lot of people are thinking that she fell on one of those augers, and that's how she fell onto the rake. But I don't know. I don't know. But the biomechanical engineer did talk about push force. If somebody had pushed her, that there would not have been enough force in the push to be able to do the damage. But I think her bigger issue was a push onto the rake would not have caused the wounds at the angle that they were at. And then when the state was doing the cross-examination, and I know Indiana Girl has some pretty meticulous notes on this, so that might be helpful here for my memory. So the state was trying to show if the rake was up, would that have worked? And then it was ultimately figured out that it couldn't work, which is when I said that I'm probably wrong then about the rake being up against the wall, because that's what my original theory was, because of the height of the rake being only 30 inches. So then that theory wouldn't have worked. And she does talk about with the push, the way the body, if you push somebody from, like, you would be top heavy, so essentially it would almost kind of pull your legs out from under you, and so the way you would fall would not be at the angle that which she landed on the rake. They all did, though, Kate. They all said that. The wounds of the force required is her expertise. The math checks out on the fall from on a high. Yeah. There's a wall. I think the bio lady was saying with the force of a push or a Hulk smash, LOL, can't account for the different depths of the punctures. Wouldn't all four go in and stay then? Yeah, that was like for the wounds E and F. She was talking about that there's no way to get that angle. Yeah, I remember that. Like, there was no way to get that angle and not have at least 3 of them go in. And I am by no means a biomedical engineer or biomechanical engineer, so she didn't die somewhere else and somebody put her in the shed. I think that we have to make the state even trying to represent that as what happened was, one, never their theory, and 2, they couldn't get her out of the barn with the rake because the door was frozen shut. There's no way they could have killed her outside of the barn with the rake and then brought her in. So here is, yeah. Do you really, Dan? You know what? That would not surprise me. You have that brain. That is your brain. Your brain works like that. So this is where she's found. So the door is here. You come in the door over here, and then you walk down, and she's found here. According to Todd and Tristan. Well, once again, you can't get her into the barn. Even all the cops that went there later even said they couldn't get the door open. That is a terrible photo. Why do I have such a small, tiny one that's so blurry? Where is my other one? And then this is the width from the totes to the door. This is the aisle with the pet carrier. So right where this photo is being taken from is that same corner that she's found in. And then you can see right here this little gray outline. That's the pet carrier. That corner's like full of junk. I have a way better picture. I just don't know where the hell it is. This one that's closer to the, I kind of just use this little circular wood table-y thing, kind of as my general location of where things are happening. Actually, only 2 were super deep. B and E. C and F are the middle ground, and then D was the least. But A is the main one that has the internal injury where everything was being moved around. Nobody actually knows where that takes place. She crawled to her final destination. The expert said she would have lived for a few minutes. Right. Bio lady said, if I need a red dress and I find a blue jumpsuit, it doesn't matter the size of the jumpsuit because I need a red dress. And I said, clocked it. Red dress. He says the carrier was 30 feet away from it. Right. We don't know where in this barn it took place, but still, either way, I think the whole point is it didn't take place outside of the barn or outside of the shed. Did you just say tuchus, Dan? She fell laterally and pinned the handle with her tuchus. She tried to sit up and couldn't free herself. I'd guess pneumothorax, hemothorax, perhaps cardiac, and for the conclusion, CPR likely ineffective. Pneumothorax, blood, air, imping, oh my God, I can't speak. The lung expansion. So the way that she kind of explained it is like she impales herself on 1, 2, 3, right? 1, 2, 3, and then and it is down by her tuchus, and she can't sit up directly because it's now underneath her. So she tries to roll over, and then in rolling over, she kind of falls back, which moves it from C to D. It moves like time 3 from C to D, and then she's still trying again. This is the one that we were kind of trying to figure out is, does she actually get to her knees, get up, and fall against something else, or fall while she's on her knees? Because now the times 3, 4 are moved at a different angle because she's tried to get it out of her back, and falls back against it and then impales herself on 3, 4, therefore making it so wound E, which is now number 3 time, is now again as deep as B, if that makes sense. So I think that this is all happening because she's trying to get up to save herself. That's where I'm at. I don't get mad at anybody for their opinions on a case. I never do. I cannot get past how is there more holes in her body and than there is in her clothes, but somebody is impaling her with a corn rake. And so even if we go with the push theory, if you think that that's what happened, so does he like pick her up just a little bit and then pushes her back down on it? But if you're pushing her back down on it, then it doesn't really, your push force, it would have to be different. And then the math of how deep the wounds are would change. I get, that's me. I don't know. Isaac does. Her clothes are actually keeping the tines inside her clothes. But yeah. Not to mention, he had no idea she was in there without following right behind her. It would make him an evil mastermind while also being completely stupid. Yeah, he'd be like, okay, go get the pet carrier. And then he's like planned this whole thing that she's going to get the pet carrier, and then this is where he's going to go and impale her on a corn rake. The first trial, that was not their theory. The theory of the state has changed. If that's not concerning, I think we should probably look at that just in itself. Why would their theory change if they knew they were right the first time? There should be no reason to change it if you've already proven your theory, right? Why aren't you sticking with it? It's kind of where I'm at. I don't know. No other tools. I mean, there's other odds and ends shit all over this place. I don't know. Do I have the picture? Because there's also, this is like that old hay rack, and there's other random ass shit in here. I don't know. It just seems like it does have some kind of randomness to it. Okay, let's get back to it.
I think it's undated. I want to show you Exhibit 233, which we looked at yesterday. It's a letter from Mr. Mullis to you. I understand. I think it's undated.
He's got cough drops again. Ugh. There's a photo for you. Mom, dad, brothers.
I can see it, yeah.
Brother, sister.
Okay, thank you. And If we can scroll, I think it starts on page 3 and 4. Very
Goodness
small for me.
gracious. They're actually showing them to us though today. Okay. Lynn, I hope you still have the sketches I made of the wound pattern and how the angle was when we found her. This is why the coat needs to be physically, and that's covered. I went in memory in those sketches, even the pictures, that's covered. Don't tell me how deep one is versus the other, or the blank went after penetration. I pulled the rake out. Those blank bent or spread wide, those blank bent or spread wide at all. It pulled straight out with little effort. I'll try my best to draw a picture. Was at first sight in the red shed. So some of this is covered. I can't see it. If they uncover it, I'll go back and kind of see if there's anything I missed. So this is how he's saying when he found her. So let me see here. Okay. This tine, I'm not sure about. I didn't really examine her that long. So the third tine, he's saying he's not really sure about. Or actually, that would be the second because he's got the handle. This is not a great drawing, but let's see what we got here. The handle going this way, so this would be tine. This is 1, we're at 2, or tine 3 if you're counting this way. So we'll go with tine 3. I know this tine, so tine 4, was not in her when I looked before I knelt down, then tried to get her out, then simply pulled it out easily with one hand. So he said this tine was not in her. Okay. Granted, if I had had a torso model with the wounds marked, I could definitely get this down to pattern. The wounds that I wouldn't have known till the photos looked to be more square with the body like this. Okay. The distance, some wounds, the distance, the sum between tines. Lynn's probably going, what the fuck are you talking about, Todd? Tines were not bowed or spread apart. It would have made pulling out hard versus, okay, this says handle. Remember, this tine was cut when we found her. Oh, this tine was out. This tine was out when we found her. So tine number 4 over here was out when we found her at a compound angle. I don't know what the distance is, but it would be greater than a square on hit. Okay. This distance, some wounds. Some wounds were this distance apart from tines 2 and 3. This distance, the sum between tines. Gotta have 3D model. Get torso. I could have it done in a few minutes and all would understand. Okay. So this is the letter to Lynn, his sister.
Did you understand Mr. Mullis to be asking questions here about investigating a theory that Amy died from an accidental fall?
You want me to go back and read this? He's got a whole legend. Okay. All right. Well, this is 18. Push on issue that, I don't know what that says, that little word on the top. Push on issue that I never knew of Jerry affair and how I can't tell what that word is. Let me see context. Makes it look like we did, or at least I did. And how, I don't know, is that Estali? I can't tell what that is. Number 19, taped interview of mom and dad, Tristan knowledge, PS argument. Number 30, Amy observation with murder stories. Oh, Amy's obsession with murder stories shows how the falsified, maybe fortified her history of manipulating everyone with multiple personalities. Ooh, her parents plus selection of friends at different situations. Her dizzy spells and moods. My trying to help plus history of her problems. Oh gosh, Todd. How it something with kids. Her high expectations, her history of cheating. It would be something if she does something. Number 28, Tristan plus my relationship, his and Randy's. Number 22, Randy. 23, Terry stuff. Oh, Terry Jeff. Number 24, PK. Number 25, the farm history of work over the years, her role, my family, plus relation with kids and us as parents. Number 26, vacations discussions. Okay, like we're planning on going on vacation. Why would I kill her if I'm planning a vacation? Number 27, close. 28, my paying her debts, my role as the bookkeeper, her idea. Number 29, the Fullers, their internal problems. Number 30, how she ran the show, more or less. Number 31, Keith plus cops plus influence, their knowledge parties. 32, Jerry. 33, my giving to friends, etc. Very Amy. Is there only expert that could verify possibility of it being accident, that fork never truly was totally out of far right wound? Plus each could easily be from something. Did she know something? Okay. Okay, so let me see what the next one is here. I thought there was more than one. Is that all they show us, is just those 2 pages? Okay. Well, we'll see.
Did you understand?
Problem is this says it wasn't dated, but if it's mailed out from the prison, we all know that it is. Night, Dan. Go get some sleep. And always nice to Kate. I actually really like Kate, whether we agree on cases or not.
Mr. Mullis to be asking questions here about investigating a theory that Amy died from an accidental fall.
Certainly that's what he's referencing there in the photos or the drawings that he made. But I don't know when. But without a date.
Would you agree that?
Just put pictures of her wounds. Don't tell me how deep one is versus the angle or the angle of it. Okay, so we just saw that one. Okay, I don't think I can even see that. I'm going to probably have to. Oh my gosh. I don't think I can read this one. This is super blurry. Reputation stuff being male related, looked up more porn and stuff than I did. Oh shit. Okay, right off the bat. He's like, she was looking up more porn than I was. And this, okay. And this shut Travis something, all computer stuff being male related, and looked up more porn stuff than I did. I something down to Tristan and his testimony. He is too something. He is absolutely certified, no, certain in this. Oh, he's absolutely certain in this. I think, and in the text to Terry, I think in the text to Terry could possibly be got Terry something when something lawsuit. I think the auger was, no, the auger was married, 40-year-old. I don't know what that is. Ozzy? A 17-year-old boy and would get fired or something. It's possibly this, but I don't know for sure either. Why, if Amy said shit, I don't know. This BS about me putting Taylor in snow and other crap is such bullshit. I just something me or Dr. Thompson. I'll leave the I'll leave. I don't know what that any of that is. Something, something, something. He didn't know what the angles were. Dr. Thompson didn't say what. Something except the bruises on Amy. He said the bruise. He said the scrapes and hand scrapes could be from that morning. My mind, it scrapes. This gets really blurry. I don't know. Her head was here when we found her. Oh, he's got another little drawing over here. Her head was here when we found her. I cannot tell what that drawing is. His is getting old. Sounds when one actually looked at clothing, took pictures is something. Hemeth but saying that I was, hopefully we get these because this is so hard. This is so hard to pick up on.
But without a date.
Would you agree that this would be a letter that Mr. Mullis sent you before trial?
Oh, yeah, yes.
And do you recall Mr. Mullis asking you to investigate how the far right tines did not come out of Amy's body?
I don't remember that specific question, no.
All right, if we could go to the first page.
Well, we have to remember one of those cameras never recorded anything. It had nothing to do with anything, and it never recorded ever. It got hooked up and it never recorded. So that goes to show that that has nothing to do with anybody doing anything to the cameras except for there just being an issue with the camera system. And then it was unplugged or disconnected on October 29th.
Bottom paragraph. Could you review that for me?
Okay.
Would you agree that Mr. Mullis is asking you to verify the possibility of it being an accident?
That's what it says, yes.
And then on the second line, never truly, was totally out of the far right wound.
That's what it
Kristen's next
says.
to his grandparents.
So would it be fair to say that you weren't considering, the principles of physics or Newton's law of motion when you reviewed the autopsy report.
He's like, I don't know what that is.
Excuse me, can you say that again?
Sure. Is it fair to say, based on your prior testimony, that you weren't considering the laws of physics or like Newton's law of motion when you reviewed Dr. Cruz's autopsy report?
No, I wasn't considering that type of technical analysis.
And because we're lawyers, that's why we would hire an expert.
Yes,
If you had evidence before Mr. Mullis's trial that a swing of the corn rake could not have generated enough force, would you have presented that to the jury?
well, I guess you start out, if we had that, if evidence or witnesses are helpful to a case, of course you present it.
And if you had talked to an expert and that expert explained to you that the laws of physics made it impossible for the corn rake to have been swung into Ms. Mullis, would you have presented that to the jury?
Based on that hypothetical, yes.
If you had evidence that it was impossible for the corn rake to have been pushed or kicked into Ms. Mullis, would you have also presented that?
Same answer.
Did you present any evidence that Mrs. Mullis' death was the result of an accidental fall?
No,
And when Todd took the stand to testify, did you ask him any questions that would support that Ms. Mullis' death was the result of an accidental fall?
there may have been some questions about what he told law enforcement and medical people right after this happened, but I don't recall. I don't think there would be any other place in his testimony or I would have questioned about that.
Did you present any testimony or evidence about the prescription medications that Amy Mullis was taking at the time of her death?
I don't think so.
Did you consider or present any testimony or evidence that Amy Mullis was anemic at the time she died?
I don't think so. Todd may have testified about her being weak and dizzy when she was out in the barn helping get things cleaned up, but I don't remember if there was any specific evidence about any medical reports or evidence about her being anemic.
Do you recall in your opening statement telling the jury that Ms. Mullis was deliberately and viciously murdered?
Yes. So,
I don't know if I use those words, but yes, that's what I was telling the jury.
why?
Okay. I want to circle back to the text message evidence that was presented at trial. Do you remember there being text messages as a topic with quite a few witnesses?
Yes, I think so.
Do you recall there being witnesses who testified that Amy was unhappy or scared of Todd?
Yes.
Did you obtain copies of the full text messages or cell phone records for Amy and Todd Mullis?
I don't think we had 100% of the records. No, if that's what you're asking.
If we could show the witness Exhibit 307, the first 18 pages only. Mr. Firehill, do you know if you've seen this document before?
I really want to see what those say, and I cannot tell what they say because I'm still very curious about
The
that.
best answer I can give is I don't think so.
That message they were
If there are
talking about
text messages
yesterday.
between Todd and Amy that contradicted what witnesses said at trial, would you have used those?
Well, I'm not sure what you mean by contradict.
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy or tension?
Your Honor, I'm going to object on the grounds of 5403 and relevance. This evidence is not admissible, and so it's immaterial, but it's also a report that was generated by Mr. Castle and wasn't a part of the underlying record at the time Mr. Firehelm even represented them.
I guess, Ms. Nichols, did you want to respond to that?
Oh, okay, I can kind of read this. Bin 1 empty, 32, dead week, about 15 minutes out. And that is from Todd to Amy. Check when I get home, from Todd to Amy. Do you know where there is a bottle of pen? Want to give that kitten some pen. That's to Todd. From Todd is pork burgers and brats. From Todd is thanks for telling T about Allie. I cannot tell what Afy. Breakfast is ready. And these are from 11:10. This is okay, so it's backwards in time. So this the top one that I just read about the bin 1 empty, 32, dead week, about 15 minutes out. That one's from the 10th at 2:34 p.m. UTC. FYI. And then let me see. I'm just trying to see what the this is then that was the 9th. Now we're at the 8th. From Todd, what time you want tea ready? From Todd, that'll work. To Todd, are you and T going hunting? We can do something tomorrow if you are. Bruters, maybe? From Todd K. To Todd, I'm going to be down for a bit. I am so tired. That's the 5th? The 5th or 6th? No, that's the 8th. That's the 8th. The 7th, I laid steaks out. Will you be able to cook them? This is their contentious relationship vis-a-vis text messages.
Your Honor, it's already admitted. I am not asking this witness to admit it. It's the whole point, right? He didn't have this information because he didn't request it, and he could have used it to impeach the witnesses at trial that talked about messages with Amy that the state relied on.
Right. Kelly, can you read me back what the question was?
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy or tension?
Yeah. The objection's overruled.
Mr. Firehelm, do you need the question again?
I would love to know what this is. Thanks for telling T about Allie? I don't know what that is. And then it's like breakfast is ready. What is she telling? What is she thanking Todd for? Telling T about what?
Please.
Did you understand the state's evidence at trial, or would you characterize it to be attempting to show that Todd and Amy were unhappy, or that there was tension in their marriage and in their home?
Yeah, I think that's fair.
So we're going to scroll down here, looking. Page 14.
I'm assuming that T is Tristan, but it also could be Taylor. But so it could be either one, but it seems that he did a lot of the sports stuff with Tristan and she did a lot of the sports stuff with Taylor. I don't really know. Yeah, it's too blurry, and so I don't want to misstate what it actually says. But okay, so we're on the 7th. Do you know what bin's empty? Well, that's weird because that's from the 7th, and he doesn't respond to that until the 10th. Maybe they had a different conversation. Maybe they talk about bins being empty all the time. I don't know. To Todd, got an email. We need to order nursery feed today. You may want to call Jerry because he usually does that. To Todd, we need to leave in about 25 minutes. To Hannah? Oh, to Nana. Thanks, got my work out in, chores done and voted, and now I'm on my way to hospital. Todd will text you later. I think my time is 9 or 9:30. Love you. Okay, from Todd. Okay, just got sheep moved. To Todd, forgot I left for Manchester, almost home. From Todd, hasty. To Todd, had 8, oh, he said nasty, had 8 dead something come out of my hair when I showered and picked up another off the floor. Flies, maybe? And he says nasty. She's telling him that she has dead flies coming out of her hair in the shower? Okay, home. This is from Todd. Went to Sandy's, got just by panel and wide 10-point laying down 40 yards away. No shot, just watched. Just watched him trot off. Okay, that's when they went hunting, apparently. To Todd, don't be. Okay, T is missing you. She's been a little tearful. So T, that's Taylor. So yeah, because she's saying, don't be something. I can't tell what that word is. T is missing you. She's been a little tearful. It's got to be that. So T's probably Taylor. T is missing you, missing Todd. Um, $709. Okay, I will be. Okay, so, oh, don't be late. That's what that is. Don't be late. T is missing you. She's been a little tearful. He responds, K, I will be back earlier now. I hope I get this in the FOIA. I know. Let me see if I have any new emails. Probably not. No email.
And I think I can direct you to line 233. And then 234 after.
I love you.
You need to scroll a little bit. I can't see
Hey, Todd.
233.
Love you, honey.
Okay.
Of course they zoom in
Can
on
you
it
tell me
now.
what the dates are for line 233 and 234?
October 14th, 2018.
Oh, we didn't read this.
And this would have been shortly before Ms. Mullis passed away?
About a month.
A month, yeah.
And would you agree that the
Okay,
content of these messages contradict the state's narrative?
Yeah, those two do, yes.
Okay, we can take that one down.
I didn't have dead flies while you're doing roadhead.
Mr. Firehelm, did you take any steps to impeach or discredit
Right.
The witnesses who testified at trial regarding Todd and Amy's relationship.
Well, I guess the record would speak for itself. I think we cross-examined them, but I don't recall specifically.
I'm sorry. Did you take any steps to determine if Amy Mullis had a Facebook account?
I don't remember.
Could it have been helpful to you to present evidence from Amy
The mama cat died.
that her and Todd were happy?
Yeah, I suppose it could have been interesting or relevant to the jury, inconsistent with what was going on, but
Inconsistent with what? I heard his lawyer whisper, "We can't get it in any other way." Do you know what it was in regards to? When did they say that? Because I really dislike the half-bald prosecutor. He's so I know he's like so snooty. He's just like I'm gonna rewind it for just a minute.
Regarding Todd and Amy's relationship.
well, I guess the record would speak for itself. I think we cross-examined them, but I don't recall specifically.
I'm sorry. Did you take any steps to determine if Amy Mullis had a Facebook account?
I don't remember.
Could it have been helpful to you to present
Back up more?
evidence
Okay, hold on.
from Amy?
I'm not gonna do anything.
I'm gonna scroll down here. What page? Page 14.
Is that too far?
And I think I can direct you to line 233.
Nah, I don't agree with that. You look like a
And then
fool with the
234
biomedical
after.
engineer.
You need to scroll a little bit. I can't see 233. Okay.
Can you tell me what the dates are for line 233 and 234?
October 14th, 2018.
And this would have been shortly before Ms. Mullis passed away?
About a month.
And would you agree that the content of these messages contradict the state's narrative?
Yeah, those two do, yes.
Okay, we can take that one down.
You can't take it from me?
Mr. Firehelm, did you take any steps to impeach or discredit the witnesses who testified at trial regarding Todd and Amy's relationship?
Right there. Can't get it in any other way.
Well, I guess the record would speak for itself. I think we cross-examined them, but I don't recall specifically.
I'm sorry.
I agree.
Did you take any steps to determine if Amy Mullis had a Facebook account?
I don't remember.
Could it have been helpful to you to present evidence from Amy that her and Todd were happy?
Well, they weren't. Okay, that makes sense. But he's like, it would go against everything that was happening because it doesn't make sense in context.
Yeah,
I
I
agree.
suppose it could have been interesting or relevant to the jury, inconsistent with what was going on, but
I agree. I agree with him. A lot of people think that he thinks Todd did it. To me, I just kind of think he thought
So,
it was
Mr.
murder.
Fairholm, do you recall reviewing phone records from Terry Stainer?
I might have, but I don't think so.
Do you recall Terry Stainer's testimony at trial?
Not in any way I could talk about it today.
If I represented to you that the transcripts indicate that Terry Stainer was testifying about Amy being upset or
Agree.
scared of Todd, or that she testified about Amy saying, "Look for me in the timber," would you agree with that?
Yes, I think so.
If we can show the witness 372.
I think he absolutely thinks that Amy was murdered. He probably also hasn't looked at any of the new reports, along with Kelly Cruz, Travis Hemsath. See, that's so interesting to me. It's like that's how like the world sees things. That's how we're all so different, and why it's so interesting to see the other points of view. Because for me, when this crime happened and he first went to trial, I was like, this is an accident. Like there's just no question for me that this is an accident. Like I just don't even I can't even wrap my mind around something else. Like, and it doesn't have anything to do with this PCR because I already felt that way. Like, so I've been waiting for him to get this hearing. So it's so interesting how the world just sees things so different. And honestly, like, so my chat right now is probably, obviously very heavy in that he's innocent or at least deserves a new trial. But like you guys were saying yesterday, if you watch like the Law and Crime channel, if we watch the comments on the post conviction, a lot of people think he did it. I mean, she refuses to change anything. She testified that she had already said it was a murder and that the autopsy confirmed, or that it was homicide by another person, and her autopsy only confirmed her thoughts. So she went into the autopsy thinking that she was murdered, and she refused to look at any other evidence. And she said that on the stand. That's her testimony. He could have brought up more about the kittens with Tristan, and at least show he has a loving, softer side in contrast to what the state was picturing, that he is human. And he says, yep, totally interesting. I didn't think he did it before this. And then we had this hearing and I'm convinced he didn't do a thing, right? I know, that's where I'm at. The new attorneys didn't introduce anything new proof-wise. His original attorney covered all this. I don't know why they're bashing him. He brought all of this up, but he didn't. He didn't bring any of this up. He never got an extraction of Amy's phone. He just said, like what they're talking about right now, he never even looked at that. But it's interesting that her notes said it could have been a fall. So that is interesting too, because he testified yesterday. He didn't testify yesterday, but we watched his testimony yesterday where he says he never even saw those notes. Like never even turned over to him by the state. But I'm assuming that they would say, well, it's not exculpatory, so it doesn't matter. No, never called an expert witness. Never had anybody look into whether it could be an accident or not. He just believed the medical examiner. Even though Todd was telling him it had to have been an accident, he did not care, and he never hired or had anybody look at it to see if it was anything other than what the state said it was.
Do you know if you've ever seen this before, Mr. Fairholm?
The best I could do is I don't think so.
And can you tell what it is?
It looks like phone records And at the top, it says, David Stainer.
If these phone records would have impeached Terry Stainer, would you have used them at trial?
Sure.
Oh.
If they would have discredited her about Amy coming to her house crying
Oh.
in October 15th, 2018, would you have impeached her with proof that Amy didn't?
Sure. Anytime you can discredit a witness, you try. I don't know how this would do that, but yes.
Okay, we can take that one
It's saying
down.
that her and Amy talked on the phone at such and such time, and this is saying,
Mr.
no, they
Farham, do
didn't.
you remember a witness by the name of Corey Volker?
I don't recall that name.
And you don't recall any investigation into Mr. Volker's relationship with Amy?
Poker? A new name.
I'm not connecting that name with her, no.
Ooh, who's that? Who's Poker? What'd they say his name was?
Remember a witness by the name of Corey Volker?
Corey Volker.
I don't
Who's that?
recall.
Corey Volker.
Do you recall having in discovery text messages between Amy and Corey Volker?
Corey
I'm not
Volker.
recognizing that name.
Would you be surprised to learn that Mr. Volker knew about Amy's affair with Jerry Frazier?
Again, without picturing him or linking him somehow, I'm at a loss here.
We could show the witness 268. So, Mr. Farham, can you look at this and tell me what it is? To the best of your, I guess, ability to identify it.
Oh, text messages to Corey
it's-
Volker.
SMS text messages. It says Corey Volker.
And have you ever seen this before?
I don't think so.
Science says he didn't do it. I wonder what that conversation was about and why.
Okay, we can take that one down.
You want me to go back and see if I can see that one? Okay, hold on. November. No, no, these are like November. I can't tell if it's a 5 or a 6. Yeah, I know Amy Way about if people are gonna be pissed, can't make everyone happy. So there are 2 yes and 1 no. Okay, hold on, let me go to the bottom. This looks like it's like 10-5. Will you leave him alone? He's busy. That was to Corey. And then to Corey, you're tapping into my Frazier time this afternoon. Oh, so Corey is friends with Jerry, and Jerry is busy with Amy. So she's saying, hey, like stop messaging him or stop calling him. Okay. You're tapping into my Frazier time this afternoon. And then now into November, who the fuck something you that? Who the fuck something you that? More? That doesn't even make sense. Who the fuck went you that? I don't know. And then Corey responds and says it's a secret. Then Corey says, I know you will vote to change the shed. What? And then 2 Corey says, on the horse yet? On the something yet? And then Corey says, fuck it then, I got leverage. And Corey says, I like to win. She tells Corey, you already do win. Why would you need it changed? And then Corey says, or to Corey, she says, yeah, I know. No. Yeah, to Corey, yeah, I know. Any way about it, people are going to be pissed. Can't make everyone happy. So far, there are 2 yes, and 1 no. I have no idea. This is just more people that know that that think that that just know that Todd's getting cheated on and nobody's fucking telling him. I'd like to see what that one is. We leave him alone, he's busy.
We can take that one down.
You did, everybody knew except for Todd.
Do you remember there being witness testimony about Amy screaming and getting into a fight or being upset with Todd?
About his mom?
Oh, looks like Mr. Firehome is frozen.
Mr. Firehome,
Corey's
are
a
you able to
dude.
hear us?
Yes, I can.
Okay.
Okay, so Corey is married, and looks like he works at a farm store or owns a farm store. He lives near where they lived. He's got kids. Weird that he's got kids named the same names as Todd's kids. Is that not fucking weird? He has a Tristan and a Wyatt, and then a Memphis. But he has a Tristan and a Wyatt. Okay, that's fucking weird. That's weird. That's weird. They have the kids have the same name. Yeah. So yeah, he's just a married dude, lives in the area. Looks like he either works at or owns a farm store. No, he doesn't have a Taylor. He has a Tristan and a Wyatt. I don't know. This seems like it would be Jerry's friend. This seems like it would be Jerry's friend who is messaging or calling Jerry when he was with Amy. And so they're saying, hey, like she's telling him like, hey, leave him alone. He's busy. We're getting busy.
It looks like your video is frozen.
I don't recall a screaming match between Amy and Todd, no.
Do you recall any text messages about Amy screamed?
I'm not recalling it today, no.
The only fight I know about is more about the mom. About Todd's mom.
And did you do any investigation to determine the facts surrounding the text messages the state presented at trial?
No, I don't recall at this time.
Mr. Firehelm, you might want to turn your camera off and turn it back on. It looks like you're still frozen here, but we can't hear you.
Right now, I've lost that bar at the bottom where I can turn things on and off. All I have is that exhibit in front of me right now.
Oh, we've taken the exhibit down, so I am not sure what advice to give you. Oh,
You see me now?
yep.
Okay.
We're back. We talked a little bit yesterday about Todd asking you to have the accident theory investigated. Do you recall that?
Yes.
And I wanted to clarify if it was your testimony that Todd Mullis was just shotgunning, and if you could explain what that characterization means.
Huh?
Well, Todd would write these long letters. Well, not all of them long, but there was a lot of it. And there would be ideas or questions and so forth. And like I said, since I couldn't email him back, we would either when I went to see him at the jail or when we talked on the phone, we would address those things. And that's how I kind of interpret Todd told me and Bob, you know, I'm just sitting here, I'm thinking, I'm putting these things out there. That's kind of what I meant.
Okay, that helps.
I didn't mean what he was doing was inappropriate. It's just that's kind of the methodology that went on between the three of us.
Do you recall answering Todd about whether the two tines ever came out of the right two wounds?
I don't remember that type of specificity. I don't think we did. No.
Would you say that Todd consistently asked you about evidence that Amy's death was the result of an accident?
Earlier on, yes, and maybe continuing for a while, but I don't think that was a big issue as we came down the stretch towards the trial.
Hey, Sergeant Mike. Yeah, I'm with you. I'm with you. And they're typically not just common things. Like it's not always getting run over by a tractor. You know, weird shit happens. I mean, weird shit happens all the time. Think about like the lady found in the water tank at the hotel. Like weird. It's just weird shit.
Deposition that Todd never stopped asking you to investigate whether it was an accident?
I don't recall that specific question, no.
Wait, what?
If we can.
Yes, he's the hotel.
We will show you your deposition, Mr. Firehelm, just a moment here.
What Evansdale case?
I have it here if you want to give me a page.
Yes, if you could turn to page 23 and look at line 5.
23?
Yes, page 23, line 5.
Okay, I see it.
And so in your deposition, you testified, no, Todd never stopped asking about experts in an accident theory?
That was my answer. That's correct.
Okay.
Ooh.
I want to touch on communication with Mr. Mullis briefly. I believe you said you testified that Todd would call you from the jail before trial?
Yeah, I remember there were phone calls, yes.
Did you have concerns about the confidentiality of those phone calls?
I don't remember if the jail staff assured us that they would be confidential or not. I think they did, but I'll answer your question. No, I didn't have a concern.
So do you recall telling Todd that you couldn't say a whole lot on the calls when he would call you?
I don't remember that, no.
Do you know if you scheduled legal calls at either the Buchanan or Dubuque County jails?
I really, it would just be a wild guess. At Dubuque, we would have had to have done it in the evening, and I think I was there, but I'm pretty sure it was more than once. I know the night before the trial started, I went there on a Sunday night, but I think there were more than that.
I want to pivot now to your opening statement at this trial. Did you discuss that with your co-counsel, Mr. Sabers?
I think Mr. Sabers was there the night before the trial started. And whether or not we talked about the opening statement, I don't remember.
Do you remember testifying in your deposition that you didn't give him a copy or a draft of your opening?
That would be accurate. I don't remember specifically in the deposition, but that would be true.
That night before trial began and you met with Mr. Mullis in the Dubuque County Jail, did you tell him what the substance of your opening statement was going to be?
Oh, heck yeah, they do, silly goose.
I don't remember.
Silly old people.
Okay, I want to pivot again. I'm sorry. I feel like I just keep jumping. You testified yesterday that you visited the Mullis farm, and I believe that you looked into the shed and kind of in the farmyard.
We went to the shed where this took place, and I don't think we went into the other buildings, but Lynn and Mike pointed out, I'm pretty sure Mike was there, what the other buildings were, and like there's the 2 hog barns, there's the machine shed and so forth. And then I think it was just Lynn and I went in the house and sat and talked.
Lynn's a sister.
Do you recall taking any steps to learn what Amy was doing before her death in the hog barn?
What she was doing in the hog barn?
Right, before she went to the shed?
Just what just what Todd and Tristan testified to. And that's what Todd had told me in our conversations.
So, do you recall there being injuries to Amy's right hand?
I don't recall specifically, no.
Do you recall doing any investigation to determine if they could have been caused by cleaning the light fixtures in the hog barn that morning?
There was no investigation as to that. And I don't remember Todd or Tristan saying that had happened. Todd said he was concerned about her balance and being, she was trying to do too much after this medical procedure.
So, Mr. Firehelm, I should have shown this to you yesterday, so I apologize, but this is demonstrative 275. I don't know for sure which camera I'm trying not to cough. Do you know if you've ever seen this before? We're gonna try another camera.
That's cover to the light fixture that you're cleaning out.
Do you know if you ever saw this before?
I don't think so.
Did you ever consider if Amy was cleaning these and putting her hand in there that it could have created injuries on her hand?
Objection, speculation.
Well, no. Did you ever consider it? That's not
Did
speculation.
you ever consider if the hog barn light fixtures could have caused an injury to Amy Mullis's hand?
No,
Thank you. Thank you. Do you recall doing any investigation into farming accidents as a theory of defense?
no investigation into that, no.
Do you recall examining the corn rake that officer seized from the farm?
During the trial, yes.
But not before. Is that what you're telling me?
Yes.
So did you see the blood on the handle of the corn rake?
Not before the trial.
Did you take any investigative steps to determine how the blood would have gotten there or whose blood it was?
No.
Do you recall Todd asking you in letters to look at the rake and the physical evidence?
I think he did, yes.
Did you ever look at Amy Mullis's clothing from November 10th, specifically the coat, the sweatshirt, and the long sleeve shirt that she was wearing when she was injured?
No.
Never looked at any of the clothing.
Did you take any investigation into the holes in the clothing in relation to Amy's injuries on her body?
Well, when you say investigation, I mean, there were photographs in the reports that were made part of the discovery, but any specific investigation or having some independent person look at them and so forth, no.
Did you take any steps to reconcile Dr. Cruz's opinion that the rake would have been swung 2 to 3 times, but there were only 4 holes in the coat?
No, I don't think so.
And Mr. Firehelm, are you looking at your deposition? I see you're looking down.
I have it right here in front of me, yes.
Okay. Any objection?
It's like wind. It's kind of crazy to wind on their camera.
Do you recall looking into the security camera system at the Mullis farm?
No.
It was either Mike or Lynn showed it, the one camera over in the machine shed, I think, that was not functioning.
Do you recall testimony from state witnesses that the security cameras were not working November 10th, 2018?
Gabby, he did the bare minimum.
I don't know if they testified that all security cameras were, but the only one I remember there being concern or testimony about was that one. Because I think it would have been directed towards the shed where this happened.
Do you recall Deputy Himsath testifying that the cameras had been turned off?
I think he did, yes.
That was so bad. So bad. Oh shit. Oh. Oh man. Oh man. Oh gosh, Soulshine. You got me. You got me. What did you miss? Yeah, so there was like some crazy wind blowing. On the like in the mic. And so I was like, that's like the crazy wind blowing. And then Soulshine. It's Amy's ghost. We don't know how much she likes blowing stuff. Oh.
If you had evidence that Todd was not on the farm when that happened, would you have presented it to impeach Deputy Himsath?
I'm so bad. I know I'm so bad. I'm sorry. You guys, it's just so my sense of humor. I can't help it. Come on. I want to hear the question. You guys are just too quick on. You're too quick. You're too quick.
I'm not recalling him Seth's exact testimony about whether or not he thought Todd turned them off or when they got turned off. So I don't know how I would have used it.
Do you recall an inference that in committing murder, Todd would have turned the cameras off that the state was trying to make?
Well, yeah, I think they were trying to create whatever inference they could.
And if you could have rebutted that inference, would you have?
Sure.
Did you do any investigation to determine whether Amy Mullis or her boyfriend Jerry Frazier could have turned off their surveillance cameras to hide their affair?
No. That's what you guys think happened.
And you didn't consult any expert about the surveillance footage?
No.
And do you remember
The wind again.
doing any investigation as to whether the camera lost signal versus things were deleted?
No.
Okay. I think yesterday we talked a little bit about hearsay objections and your motion in limine. Do you remember that?
Yes.
Did you know that by failing to make an objection during trial that you were waiving that issue for appeal?
Hey, Donnie, I know.
Yes.
It's perfect, though.
Did you have any discussions with Todd about waiving that appellate issue?
No, I don't think we did.
If the transcripts reflect that you didn't make any hearsay objections during the testimony of Terry Stainer, would you agree with that?
I think I would, yes.
Would the
You
same
mean
be
two
true then for
object-
Patricia
You
Christopher?
made 2 objections during trial and 2 objections during the state's closing argument.
I think so.
Would the same be true then for Patricia Christopherson
I think so.
and Carrie Callanan?
Yes.
Why?
Do you remember discussions with Mr. Sabers about seeking a change of venue for the trial?
Yes.
Let me start over. Was venue changed from Delaware County?
Yes.
And where did it go?
Dubuque County.
Did you consider asking for an additional change of venue from Dubuque County?
I don't know if we considered filing another request. I think Bob actually maybe was the one that made the comment that we had gone from the frying pan into the fire as far as publicity and so forth.
Did you know if both Delaware County and Dubuque County share a media market?
Yeah, well, I know that from growing up, the Telegraph Herald comes out of Dubuque, the daily paper, and the Waterloo TV station cover, I think, both counties.
Makes me think of Idaho 4.
Do you recall expressing frustration to your co-counsel that a jury in Dubuque was not going to be any more neutral than one in Delaware?
I don't know if I said it or Bob said it or we both did, but that's certainly.
Did you have any considerations about whether a jury in Dubuque would have a fair cross-section representation of jurors?
I don't know if that was a comment maybe made by the trial judge or by somebody in the room, so to speak, that it was just a more populated county than Delaware.
Do you remember considering or researching whether farmers are excused from jury duty in September due to harvest?
Ooh.
I didn't research it, but I've certainly had trials where farm chores and field work came up as an issue about whether or not a person stayed on the jury or not.
That's
Do
interesting.
you remember any investigation or research into what kinds of jurors you thought could be fair and impartial?
I just relied on my experience.
Do you recall investigating whether Todd was planting crops or harvesting at the time of any of the Google searches that the state attributed to him?
Well, I know certainly Todd told us that, which I think was confirmed by Mike or Lynn or both.
Did you do any investigation or seek any documents that would have confirmed Todd was operating the planter in April and May of 2018 during these questionable Google searches?
No, I don't think so.
Are you familiar with the Farm Acre book and farm insurance?
In Iowa,
Familiar with
Iowa they
what?
are.
A
Yeah.
Farm Acre book and the concept of farm insurance, crop insurance, I'm sorry.
No, I'm not.
If you could have produced evidence that Todd did not have access to the iPad or the internet on the dates of those searches, would you have presented that at trial?
Yeah, sure.
Do you recall telling the court that you had a family issue come up during this trial?
Yes.
And would that have been distracting to you?
Uh-oh.
It was concerning, yes.
I want to talk a little bit about Jerry Frazier and your references to him or your plan with regards to evidence about Jerry Frazier. Do you remember who he is?
Yes.
Do you recall in your deposition explaining that you were going to point to him as a possible perpetrator? That was part of your plan?
Yeah, I think so.
Did you have any evidence that supported that Jerry Frazier had come onto the Mullis farm November 10th and attacked Amy?
I don't recall that.
Do you recall deposing Jerry Frazier?
Yes.
Do you recall whether he had an alibi for the time that she was injured?
I believe he did.
What?
Did you have any other evidence that you were going to present at trial that supported Jerry Frazier being the perpetrator?
Nothing other than his relationship with Amy.
Okay.
Did you have any other evidence to present that someone else was on the farm that day?
No.
This is the
Do you recall
problem.
your closing argument?
Not really. Not any specifics.
Do you recall arguing that it was a murder mystery?
I might have said that. I don't know.
Would you defer to the transcript?
Yes.
Have you ever challenged chain of custody or contamination of evidence in a criminal case?
Yes.
In your representation of Mr. Mullis, did you investigate how the corn rake was handled by law enforcement?
No.
I don't recall doing that. No.
Do you recall considering whether additional forensic testing of the rake could be helpful to you?
I don't recall considering that. No.
Can I have just a moment, Your Honor? I think I might be done.
You can.
Is Comb Over going to do his cross or nostrils?
I'm going to step away and lock my front door so we don't get interrupted.
Okay, thank you.
There's the wind again. All right, let's go, guys.
Do you remember there ever being a time that Todd Mullis agreed with you that Amy's death was a homicide?
I don't think he ever said those words, no.
Nothing further from the applicant, Your Honor?
And does on the stand.
Cross-examination, Mr. Duden?
Yes, Your Honor, but I wonder if now's maybe a good time to take an opportunity for a bathroom break and to reset. If possible, we could take like a 10, 15-minute recess if that's okay.
We certainly can. Let's go ahead and take about 15 minutes. We'll plan on picking up at 2:25. Mr. Firehelm, I will just leave the Zoom on so you can stay logged in and everything should hopefully.
For instance, as well as sex abuse and things like that as well, yes? Rape, for instance, as well as sex abuse and things like that as well, yes?
We missed the beginning of that.
So you have a wide array of experience for high-level felonies and trying those cases. Is that fair?
Yes,
So turning your attention to this case specifically, it's fair to say, I think at this point, you would agree that you represented Todd Mullis in this case, right?
correct.
When did you begin representing Mr. Mullis?
Probably in March of 2019, I think.
If I told you that I believe you appeared in the case around March 8th of 2019, is that right?
That sounds right.
And so you appeared shortly after the criminal complaint alleging that he had committed murder in the first degree was filed, right?
Correct.
As you mentioned on direct examination yesterday, I believe you said that you were referred to this case in order to assist Mr. Sabers. Is that fair?
Yes.
Why did Mr. Sabers need assistance in what was your understanding?
That he did not have jury trial experience at this level of offense.
And so it's fair to say that your experience would be an aid to both Mr. Mullis and Mr. Sabers in trying the case. Is that right?
Yes.
But you did not outright assume the case. You first met with Mr. Mullis's family. Is that fair?
Yes.
That included his sister and brother, I believe, right?
Yes.
And at that time, you talked about the case, right?
Yes.
You also viewed and inspected the property where the murder occurred, right?
Correct.
Is it safe to say that after you drove from I believe your office is based in Des Moines, to Delaware County, that you spent a sufficient or extended period of time discussing the case before taking on any representative role?
Yes.
Did you also speak with Mr. Sabers before assuming the role of counsel in this case?
Yes.
And of course, did you also speak at length with Mr. Mullis?
Yes.
So ultimately, you appeared in the case, but by that point, you'd spoken to multiple people about the facts and circumstances surrounding Amy Mullis's death and Mr. Mullis's charges, right?
Yes.
At all times during your representation, taking it from a big approach or kind of a macro approach before we go to a micro level, you maintained that Mr. Mullis was innocent and did not murder his wife, didn't you?
That's correct.
So at no point in time did you encourage Mr. Mullis to plead guilty. Is that fair?
Yes, that's very fair.
At no point did you encourage him to plead to a lesser offense level or level of murder or manslaughter, for instance?
No, sir.
So at all periods of time, I believe, is it safe to say that you believe Mr. Mullis was innocent?
That's correct.
And that's what you held out to the jury over the course of this trial in this case, correct?
That is correct.
So in your investigative steps, as we kind of work our way up towards the trial, again, you interviewed Mr. Mullis's family, yes?
Yes.
And you regularly kept in contact, in fact, with Mr. Mullis's siblings who were assisting in providing information and conveying information between you, Mr. Sabers, and Mr. Mullis, who was very active in his case's defense, right?
That would be correct.
You reviewed letters,
Yes.
took phone calls, is that right?
Yes.
Not just from Mr. Mullis, but also from his siblings or family.
Yes.
And in this period of time of about 6 months, it was not just at the beginning that you took these steps, but you followed that all the way through to trial as well, correct?
Yes.
Now, directing your attention to what has previously been marked and admitted as State's Exhibit F in this case, I believe Mr. Bakke is going to put it on the screen for you if that helps as well.
I have it in front of me.
Perfect. Well, we'll jump right in then. Do you see the email correspondence marked as Exhibit F on your screen as well?
Okay. After again reviewing the medical examiner's report in the, okay, so this is from Jake to Bob Sabers, CCing Christy Klein. I think that was the person that worked with them on the case, but not an investigator. Okay, after, dated April 6, 2019. After reviewing the medical examiner's report and the photos we do have, I am almost certain that her death was not a result of accidentally falling on the fork. The number of puncture wounds, the fact that she had several layers of clothing on, the abrasions on her chin jaw, abrasions on her hand that I will bet will be described as defensive wounds, all lead me to conclude it was a homicide. I expect we would need to have our expert take a look at the state's examiner's work, but I would be surprised if he disagrees. Our memory may be better, not our memory, our money may be better spent on getting a good private investigator involved. I don't know how well the scene was examined by law enforcement, and with the passage of time, any investigation by a forensic examiner now may be quite limited in what could be found and how reliable findings would be. I suggest we focus on deposing those who were first on the scene so we can determine where to go from there. There may be two theories of defense. One is that Tristan is, here you go. One is that Tristan, our alibi witness that proves Todd could not have committed the murder. As far as I can tell so far, he has been very consistent in what he says happened. The state, of course, would want the jury to discredit his testimony due to his relationship with Todd, but in my experience, it is hard for anyone, especially a young one, to come up with a false story and be able to be consistent. The second theory, which would incorporate number one, is I think it's supposed to be Sadi. Oh, but he calls it Toddy. Okay, the other dude did it. Which would dig into her affairs and who those were with. We should have a phone conference early next week about the pretrial bond review. I have a felony sex abuse assault trial scheduled to begin in Dallas County on April 13th. Client has been in custody since mid-November, and the something informed me it is either a good plea agreement or go to trial that day. If that happens, I would have to rely on you to take care of court that day. Hope I can make it. I will send you some of my ideas on the bond issue, maybe this weekend. I thought about including Lynn on the email, but wanted to run it by you first. Feel free to share it with her if you are okay with that. Thanks, Jake. I don't think you should go with a Toddy defense when the defendant's name is Todd. I'm just going to lay that out there. I think that sends the bad message. I think a Saudi defense sounds better than a Toddy defense when your defendant is Todd.
Yes.
Now, would you have on your screen then? Do you see the email correspondence marked as Exhibit F on your screen as well?
Yes.
Now, would you agree that this is an April 6th, 2019 email from you to your co-counsel in this case, Mr. Sabers?
Correct.
In directing your attention specifically to what is the first paragraph, let me know if I read this correctly. After again reviewing the medical examiner's report and the photos we do have, I'm almost certain that her death was not a result of accidentally falling on the fork. The number of puncture wounds, the fact that she had several layers of clothing on, the abrasions on her chin/jaw, abrasions on her hands that I will bet will be described as defensive wounds, all lead me to conclude it was a homicide. Did I read that correctly?
You did.
So less than a month after you appeared in this case and the trial information was filed, this email would suggest that you believe that this was a murder, in fact. Is that fair?
Yes,
And you conveyed that to your co-counsel, right?
I did.
But this wasn't the first, this wasn't the last time that you conveyed to Mr. Mullis or even anyone interested in the case from Mr. Mullis' side, including Mr. Sabers, that you believe this was a homicide, correct?
That is correct.
Is it safe to say that you conveyed that you believe this was a murder with some regularity?
Yes.
To your knowledge, and based upon the notes, do you believe that Mr. Mullis was not supportive of proceeding with that avenue of defense at trial? Put another way, did you have any indication Mr. Mullis was not comfortable with you conceding this was a murder, but that it wasn't him?
I believe he conceded that.
What?
That you were empowered or permitted to go to trial and argue that this was a murder case?
Ooh.
Objection, misstates the prior testimony today.
Overruled, the witness can answer.
Could you ask that again, please?
Is it possible to read it back? I apologize.
That you were empowered or permitted to go to trial and argue that this was a murder case.
Yeah.
Could you hear that,
He's definitely better looking now than he was before.
Mr. Firearm?
No.
Oh, so I believe the question was, so you were, in your mind, empowered or permitted to concede at trial that this was in fact a murder, right?
Correct.
To your recollection, do you have any knowledge or recollection of Mr. Mullis telling you that you needed to correct your opening statement during questioning or the examination of witnesses?
No.
To your knowledge or recollection, do you believe that Mr. Mullis ever told you not to again say that they believe this was a murder in its closing?
No.
And do you recall that Mr. Mullis himself agreed that this was a murder on cross-examination at trial?
I believe he did.
So is it safe to say that it was undisputed that this was a murder and not an accident during the trial proceeding?
I'm going to object and ask, the question is vague. Undisputed by who, maybe would help?
Mr. Duden, did you wish to clarify your question?
Sure. So is it your understanding that you, your co-counsel, and Mr. Mullis agreed at the time of trial and throughout that this was a murder case?
I'm going to continue to renew my objection. I don't think this witness can testify as to what Mr. Mullis agreed or what Mr. Sabers thought.
Overruled.
He was on trial for murder.
I don't recall either of them disputing or arguing with me about that approach.
And to be fair, as you said earlier, Mr. Sabers, in your opinion, lacked the experience in order to be able to try this case, so you became lead counsel, right?
Correct.
Mr. Sabers did not examine any witnesses at trial, right?
He did not.
He didn't do an opening statement,
No.
nor did he do a closing argument, did he?
No.
So at all points during the trial proceeding, you were representing Mr. Mullis.
Yes.
Now, looking back at State's Exhibit F specifically,
That wind is crazy.
I'd like to direct your attention to what is paragraph 2, where you say, quote, I expect we would need to have our expert take a look at the state's examiner's work, but I'd be surprised if he disagrees. Our money may be better spent on getting a good private investigator involved, close quote.
Did
Did I
they
read that
ever
correctly?
have an expert look
Yes,
at
you
it?
did.
So even early on in your representation, you were considering hiring medical experts, weren't you?
Yes,
And you were considering hiring private investigators, right?
correct.
And you were going to investigate this case with the help of experts if it was necessary, weren't you?
That's correct.
But is it fair to say that during the course of your investigation, in your professional opinion, with 45 years worth of experience now, that you didn't believe those experts were needed?
That was my conclusion.
Looking to the course of your investigation, you did, however,
So he's the one with the most experience. Let me just put this the other way here. He's the attorney on the case with the most experience. The other guy, Sabers, doesn't have the experience to do it. And so he's saying Bob Sabers agreed with you. Okay, so the guy with no experience who can't try a case, great, he agreed. And a defendant who has never been through anything like this whatsoever doesn't argue it. He's the one with the experience to make that decision, and so they trust the attorney. He's also not a doctor, and why not have, before you just conclude that you might be right, why not have the expert look at it? You may not need them to testify or to continue, but have them look at it and see if they agree, since they're the expert. Because I guess my question, when I would be on redirect here, my question to this attorney would be, are you an expert? Are you considered an expert in this field? Do you have a medical degree? Are you a doctor? Have you performed autopsies? Why not have an expert just look at it? Just look at it and see if they agree or not. Because you, sir, are not an expert. Yeah, how can the attorney correct the opening statement? The jury already heard what he said. They can't unhear it. It's so true. Such a good point, Chris. Such a good point. Yeah, finding out left and right. And that not only his wife did him dirty, but everybody in his life essentially knew she was having an affair and nobody told him. Look at the face. I think there's supposed to be hair here. If I had to take a guess.
looking to the course of your investigation, you did, however, look at all of the law enforcement reports in this case, didn't you?
Everything that was provided, yes.
You reviewed transcripts of witness statements, right?
Yes,
You received and reviewed audio recordings or video footage when it became available to you, yes?
correct, correct.
And you conducted depositions, right?
Yes,
Before those depositions came to be, though, you also looked at this case from the perspective of electronic evidence, right?
yes,
You actually reviewed Cellbrite phone data, or Cellbrite phone dump, for lack of a better term, that was provided to you by DCI and by the Delaware County Sheriff's Office, yes?
I believe so.
That information included a review of things like the iPad in this case, right?
Yes, it did.
As well as phone records when it was necessary or relevant, yes?
Yes,
And again, you reviewed all of that information.
yes,
Looking to your depositions here, I believe you conducted around 16 depositions of potential state witnesses before trial, right? Around that number?
that sounds about right.
You conducted depositions of lead investigator, for instance, Special Agent Turbot.
Yes,
And if you recall, when you deposed Special Agent Turbot, you did so with the view that you're also going to ask about potential other suspects in the case, right?
I think so, yes.
And is it fair to say that during that deposition, you also asked about a potential affair between Amy Mullis and sheriff's deputies from the Delaware County Sheriff's Office?
I think we got into that, yes.
And so now that individual's name, I believe you know to be Rowley as a last name, as well as potentially others, right?
I think that's right, yes.
And
Wait, what did he just say? Did you hear what he just said?
do you have any reason to doubt that in Special
I think that's right, yes.
Agent Rowley Mullis and sheriff's deputies from the Delaware County Sheriff's Office.
Right here.
I think we got into that, yes.
And so now that individual's name, I believe you know to be Rowley as a last name, as well as potentially others, right?
I think that's right.
As well as potentially others. No, that's not Jerry. Hold on. I'll rewind it a little bit more so you can hear that full statement. No, he now knows about Rowley. Let me see.
Depositions here. I believe you conducted around 16 depositions of potential state witnesses before
Just
trial,
talking about
right?
deputies.
Around that number?
That sounds about right.
You conducted depositions of lead investigator, for instance, Special Agent Turbot.
Yes,
And if you recall, when you deposed Special Agent Turbot, you did so with the view that you were also going to ask about potential other suspects in the case, right?
I think so, yes.
And is it fair to say that during that deposition, you also asked about a potential affair between Amy Mullis and sheriff's deputies from the Delaware County Sheriff's Office?
I think we got into that, yes.
And so now that individual's name, I believe you know to be
As others.
Rowley as a last name, as well as potentially others, right?
I think that's right, yes.
And do you have any reason to doubt that in Special Agent Turbot's notes, he referred to Rowley as Raleigh with an A instead of an O? Does that sound or ring a bell to you?
Yeah, it kind of does ring a bell, yes.
And in fact, you asked about those circumstances in that report when you deposed him, fair?
Yes.
Drawing your attention to what's previously been marked as State's Exhibit G. Do you have that exhibit in front of you, Mr. Firehelm?
I do.
And to be clear, would you agree that this is a chain email or correspondence between you and your co-counsel, Mr. Sabers?
Yes.
And would you agree that both of the messages depicted here fell or came from, were sent on Thursday, April 4th, 2019?
Yes.
Okay. He's probably going to end up reading it, but I'm going to read it anyway in case he leaves something out. So this is from Bob to Jake from April 4th, 2019. I haven't sent it to the expert yet, but will shortly. They apparently didn't give us the photos they took of Todd's body 5 days later pursuant to a warrant, but Todd says he didn't have any cuts or bruising, other than maybe a minor cut or two incidental to farming. Todd told me that aside from the family's interactions with each other, Jerry was the person they saw more than anyone else. Todd says he believed Jerry when he denied romantic involvement with Amy. He says Jerry was very persuasive. He'd probably be able to fool law enforcement if he's that good. Or how about Jerry's wife, or the sheriff's deputy, or Tristan? There's a couple of rumors out there in regard to the death of a guy from Manchester. He froze to death after driving off of a rural road when we had the bitter cold weather in late January or early February. The rumors are that the guy was sleeping with Amy. Oh my God. Okay. The rumors are that the guy was sleeping with Amy, and either the deputy who had the affair with Amy or Todd ran him off the road. I'm sure there's no truth to the rumor, but had Amy reignited something with one of the deputies she previously slept with. Who better to frame somebody than a law enforcement officer? I spoke to Lynn about returning an iPod of hers that she previously left at my office and then taking another gander at the red shed. Her mother thinks there's something in there. Her mother, maybe Lynn's mother, thinks there's something in there that has been missed. She's having dreams to that effect. I doubt that investigators did anything by way of looking for DNA in there, and by now I suppose the scene is compromised. In my prior musings, I concluded that eventually finding fault with the shortcomings of their investigation would eventually be the route to follow, as opposed to hiring someone to process the scene. That mark on Amy's chin looks like she went down onto something like the auger. Okay. Yes, Gerald is Jake. He goes by Jake, but his real name is Gerald. Okay. Amy does deputies. She was sleeping with definitely more than one deputy. So that's interesting.
So starting with your message, which is the smaller paragraph section on the second half of the page, you wrote to Mr. Sabers that you expressed concerns about irregular injury patterns, marks on the hands and arms.
Okay. So now this is the response. Sorry, you guys. This is the response to Bob from Jake. I have a lot of concerns similar to yours. In addition to the irregular pattern of injury, she has marks on her hands, arms, and the large abrasion on her chin jaw. I realize one bruise on her arm is from an IV site from her medical procedure a few days earlier, but there are others that I am betting the state will claim are defensive injuries sustained when she tried to ward off blows. As I drove back from my meeting with Todd yesterday, I wondered to myself whether someone other than Todd did murder her. Okay. I only skimmed some of the statements contained in the numerous reports where Amy shared her extramarital affairs. I only skimmed some of the statements contained in the numerous reports where Amy shared her extramarital affairs. Is it possible one of her interests felt the need to shut her up? From the statement taken from Amy's girlfriend, Patricia Christopherson, Amy's relationship with Jerry was very intense. They contemplated marriage after each divorce. At one point, Todd called Jerry's wife, but I am not certain I know why and the outcome. That may be in other documents I haven't gotten to yet.
Arms, the that you acknowledge.
Yes.
So starting with your message, which is the smaller paragraph section on the second half of the page, you wrote to Mr. Sabers that you expressed concerns about irregular injury patterns, marks on the hands and arms, the large abrasion on Amy Mullis's chin or jaw. Those are one of the concerns you shared, right?
Yes.
You also mentioned that you had reviewed at least her medical information and the specifics about a bruise on her arm that was from an IV site from a medical procedure she had days before she died, right?
Yes.
So you had accounted by this point for her various injuries that led to her cause of death.
Yes.
And again, this is when you also were evaluating the potential claim of defensive wounds or injuries that were not from the puncture wounds to her back from the corn rake.
Correct.
This also notes that you went to go visit Mr. Mullis in person, right?
Yes.
And if you go to the third paragraph, it also shows that you reviewed the statements taken by individuals that you were asked about on direct, including Patricia Christopherson, right?
Yes.
And an individual by the name of Jerry, who ultimately was a subject of the case, or Jerry Frazier, is what you came to understand, right?
Yes.
So at this point, is it safe to say you were looking at this case from other potential suspects, right?
Yes.
And matters that of what happened months before even this case began.
Yes.
And so you knew about people who were supportive of Amy Mullis, for instance, or her friends in their statements, right?
Yes.
And you knew that they would potentially testify in this case too. Fair?
Yes.
If you flip to the second page of State's Exhibit G as well, there's a message dated also from April 4th there from your co-counsel, Mr. Sabers, directed towards you as well, correct?
Yes.
And in that message, you also discuss the autopsy report and accompanying photos, correct?
Correct.
And you even discuss down to the depth or distance between certain wounds.
Okay, this is from Bob to Jake, April 4th, same. Oh, here, there's a question up here that says that Jake had asked, have you forwarded the medical examiner's report on to our expert? So this is from Bob to, so that's when he says that no, he had not. So that was the response. So this is prior. So it's like they're going down the email chain versus up. So we're reading everything kind of backwards. So you'd have to try to make that make sense. What do you make of the autopsy and accompanying photos? The medical examiner doesn't state that she believes the corn rake was what caused Amy's wounds, just that she died of sharp force injuries. The corn rake tines are 3 inches apart, and her wounds don't appear to be evenly spaced at 3 inches apart, or even close to 3 inches apart. Some are closer than 3 inches apart, and some are further than 3 inches apart, and they're not in a straight line. Is there any significance to the fact that the ME says the puncture wounds ranged from 1/8 to 3/8 inches? Close-up photos of the tines don't show blood on tines. The tines don't appear to be very sharp either.
correct?
Yes.
And as we noted from your prior message, you shared a lot of these concerns, but these would potentially come to fruition to say that there was potentially more than one strike or swing, I think is how it was referred to on direct, right?
Yes.
I'm sorry, can I, objection, what portion of G are you looking at? Page 2?
The page 2, the
Where does it, what line says swipe or swing?
Oh, that was a paraphrase, a characterization used from the direct examination testimony, Your Honor.
I'm going to object to a characterization of swipe because I don't think that word was used.
Okay, I guess the record will speak for itself. We'll move forward with a new question, I believe, at this point, unless there was one pending. Mr. Duden, did you think you had a question pending?
Possibly, maybe, I don't know. I can ask another question.
All right, let's do that.
When we had discussed a swipe or a swing, for instance, what we're really referring to is the puncture wounds, right?
Correct.
And those would be known as the 6 wounds caused by the corn rake to the back of Amy Mullis's body.
Yes.
Looking to the responsive message from Mr. Sabers to you on page 1, that big block of text, do you see that?
Yes.
And in this text, if you'd like to review it, you also noted.
What we already read.
You substantially discuss.
This is the response
Jerry.
to what we
right?
just read.
Yes.
And the other individuals, including a possible sheriff's deputy who Amy Mullis would have had an affair with, right?
Yes.
So is it safe to say that even at the earliest point of this case, you were considering other people who could have murdered Amy Mullis?
Yeah, this was very early on, beginning of April.
Yeah, things change.
If you look down as well, you would let me know when you see the information regarding the DNA evidence.
I see it.
In the individual at the latter third or so of that block of text, it says, quote, "I doubt that investigators did anything by way of looking for DNA in there. And I now suppose, I suppose the scene is compromised."
Jake.
Close
This is
quote.
not Jake's
Did I read
thought.
that correctly?
You did.
So at this point, you were also considering scene integrity, fair?
Oh, yes.
And you were
That's
considering the avenues of possibly a
Is anybody going to say that?
faulty investigation or a less than thorough investigation. Is that fair?
Sure.
Which is things that you brought up at trial, actually, right?
Yes.
And again, continuing on there, Mr. Sabers came on the case before you, correct?
Yes.
And at that next sentence, he says to you, quote, "In my prior musings, I concluded that eventually finding fault with the shortcomings of their investigation would eventually be the route to follow, as opposed to hiring someone else to process the scene," right?
Yes.
So when we talk about processing the scene, we're really talking about evaluating the scene for alternative theories or looking for additional evidence, right?
Correct.
And so at this point, you and your co-counsel had considered this as a choice, right?
This
We
is
did.
all spitballing.
And so things like an accident reconstructionist, for instance, or an evaluation probably wouldn't have been on your mind as viable avenues for the defense.
It was not.
Now, you were asked about a biomechanical engineer's.
Point is that Todd is telling you it's an accident. So why aren't you considering what Todd is telling you? That's the point that his attorneys are trying to make.
Specifically, weren't you?
Yes.
Oh, and I'm sorry, I do just want to talk about it. There was one more sentence that I figured I'd go ahead and cover with State's Exhibit G. The last sentence of Mr. Sabers' reply to you reads, quote, "That mark on Amy's chin looks like she went down onto something like the auger," close quote. Did I read that correctly?
You did.
So you knew about a potential avenue of whether or not the auger was involved in causing Amy's injuries.
Yes.
And you also knew or were considering whether or not the fall to, or the mark on Amy's chin was due to a fall injury, right?
Yes.
But it's fair to say, like before, you didn't believe that a fall was a viable avenue or claim, right?
That's correct.
And that's with more than 4 decades worth of experience predominantly focused in criminal defense, right?
Yes.
So again, returning to the discussion of a biomechanical engineer, have you ever worked with a biomechanical engineer?
I don't think I ever did with someone that had that exact title, no.
And so have you ever heard of a case in the state of Iowa where, criminal case in the state of Iowa where a biomedical or biomechanical engineer would provide testimony?
Sure, I read all the appellate decisions and belong to IAJ where we trade information like that.
So being aware of their work and the type of work that a biomechanical or biomedical engineer would do, you knew of that, right?
Sure.
And based on your experience and judgment, you did not believe that it was a viable avenue to do a scene reconstruction, for instance, here, right?
I did not. That's correct.
But looking to State's Exhibit H now, you and your co-counsel, again, were considering potential expert testimony in this case, right?
Yes.
In fact, you considered having the medical evidence reviewed by maybe an independent medical examiner or an expert witness in your case, right?
Yes.
Looking to what is the May 2nd.
Hold on a second. He'll probably put it back up. But here, Bob, so this is May 2nd. Bob, we can and probably should have the autopsy report reviewed regardless of our opinion that it was not a quote-unquote accident. Have you received a retainer for fees expenses? If not, we should address that now. I have talked to 2 other bond businesses and they both said they couldn't deal with a bond this high. I haven't dealt with an attempt to use real estate to secure a release for a long time, but I suspect that even though they own substantial land, it isn't likely there is $5 million of equity. I would have to talk to a clerk of court to determine what the procedure is if we take a look at that route, but I am not optimistic that it would work. I am not sure what to say about his emotional condition and his unwillingness to review discovery material. Based on the minimal review I have done after getting the DCI reports, he's going to have to review and respond to a lot of tough material. Probably have more to discuss later in the day regarding trial date. Thanks, Jake. Bob is co-counsel, yeah. I'm assuming him is Todd, but I don't know for sure. He doesn't specifically say. But like how he puts that regardless of our opinion that it was not a quote-unquote accident.
Case, right?
Yes.
He was looking at discovery, though.
Looking to what is the May 2nd, 2019 email message between you and your co-counsel, Mr. Sabers. Do you see the message with the title subject being R.E. Bond?
Yeah.
We know he looked at discovery, so I don't know if this is just the timing of this. I mean, he'd only been in jail at this point for a little over a month. Wait, no, this is a couple months. Okay, because he was arrested at the end of February, last day of February. So all of April, all of March, all of April. So 2 months. But he does look at it because in his letters he's referencing things from discovery. So I don't time-wise, I don't know when he does look at it, and I don't even know if this is about Todd.
That first subject being R.E. Bond.
Yes.
That first paragraph says, quote, we can and probably should have the autopsy report reviewed, regardless of our opinion that it was not an accident. Did I read that correctly?
So,
You did.
not
So
true.
in this instance, you were also considering it from the perspective of whether an accident was potentially viable.
No.
Yes.
And is it safe to say that that claim was coming from things Mr. Mullis had told you, as well as potentially his family or support system?
He never sends that to anybody.
It was, yes.
But as your investigation progressed, the medical information didn't seem to be necessary for you to retain your own expert, correct?
That
Did
was
anybody
our
review it?
conclusion, yes.
Is it fair to say, based upon the number of times you discussed it, that you actually did contemplate or research reaching out to an expert?
Sure.
But did you?
And that avenue was either not proceeded with or was otherwise fruitless, right?
That was the conclusion.
That's the problem.
Early on in the case, though, as you mentioned, I believe, or at least in your prior notes, that a bond review or lowering Mr. Mullis's bond was a primary focus at the start of the case, right?
Correct.
You spent a significant amount of work on attempting to lower Mr. Mullis's bond, right?
Yes.
In fact, you even filed for an interlocutory review or an interlocutory appeal to have the Supreme Court attempt to allow you to lower his bond, right?
Yes.
And this was noted to be a significant concern for Mr. Mullis, wasn't it?
He was extremely stressed about being in jail.
He didn't shut off the cameras.
In your interactions with Mr. Mullis, he regularly was stressed about either being in a jail setting or incarcerated or the case, right?
He was, yes.
in looking down to the next message on State's Exhibit H, which was from your co-counsel to you, sent on May 1st, 2019. Do you see that?
Yes.
In this message, based on your review, is it fair to say that Mr. Sabers or yourself had provided Mr. Mullis with the reports of law enforcement officers or investigators in the States?
I think Bob took those to him, yes.
And in fact, you and Mr. Sabers had expressed your questions or attempted to answer his questions too, right?
Yes.
But at this point in time, starting with the third sentence of that message, let me know if I read this correctly, Mr. Firehelm. Quote, he told me that he doesn't want to read them because his anxiety goes through the ceiling when he...
Okay, so Bob, May 1st, to Jake. Jake, I provided Todd with a stack of reports yesterday and told him to begin reviewing them. I provided him with questions regarding the reports. He told me that he doesn't want to read them because his anxiety goes through the ceiling when he reads things and he can't function. He thought he was going to be bailed out soon. He told me that guys who have work release are coming back into the jail with drugs and he can't stand being jailed with them and he's about at his breaking point. I'm just telling you the foregoing so you know. Todd also brought up that he thinks we should have the medical examiner's report reviewed by our own expert to rule out that it wasn't an accident. To rule out that it wasn't an accident. That there has to be an explanation of Amy's wounds not consistent with murder. Here, this is now this is proof. This is proof that Todd is saying, hey, we need to prove that it's an accident. Your thoughts? Todd also instructed me to explore whether a different company will post cash. Bob.
He reads things and he can't function. Did I read that correctly?
You did.
And again, in this message, is it fair to say that you are aware of Mr. Mullis's concerns or belief that this was possibly an accident, but that he wanted to rule it out at this point in time, right?
Yes.
Yeah, because they're
And
telling him it's
ultimately, at
murder.
the case, he didn't tell you not to proceed with conceding that this was a murder, right?
Objection. There's no foundation for that.
Overruled. The witness can answer if he's able.
I don't recall Todd ever ruling that out. Well, would you state your question again? I may have misstated.
Sure. So Mr. Mullis believed that this was an accident early on in the case, correct?
Correct.
And he held out to you that this was a possible accident at all times, fair?
Yeah.
But by the time of trial came around, Mr. Mullis himself even testified that this was a murder case, wasn't it?
I believe he did.
And so, in that point in time, prior to trial, you had prepared Mr. Mullis for taking the stand, correct?
Yeah.
You intended to engage in a review of the evidence to allow him to tell his side of the story, fair?
Yes.
And at that point in time, on cross-examination, on the last day of trial, Mr. Mullis, in fact, conceded that this was a murder, fair?
I'm going to object. I think the transcript would speak for itself, and the transcript is in the record. I believe that what counsel's referring to is cross-examination, and he's misleading or mischaracterizing the testimony of Mr. Mullis and the questions that were being asked of him regarding the evidence presented at trial and whether Mr. Mullis agreed that evidence was presented that it was a homicide versus an accident.
Well, certainly I'll have the opportunity to review the entire transcript and this section in particular. Mischaracterizing that testimony certainly isn't going to be helpful if that's what's happening. So the objection is overruled. Do you remember the question, Mr. Firehelm?
No, Your Honor.
All right. I'll have Kelly read it back since there was an objection, but you'll need a microphone, Kelly, if you want to use mine.
And at that point in time, on cross-examination, on the last day of trial, Mr. Mullis in fact conceded that this was a murder. Fair?
I believe that's correct.
Your Honor, to clear up something, may I go ahead and present? Mr. Firehelm, I'd like to show you what's previously been indicated as volume 5 of the trial transcript and what's previously been admitted into evidence as exhibit 351, I believe.
I
Directing
disagree.
your attention to page 56. I'm beginning at line 12. The prosecutor asked Mr. Mullis, and somebody came onto your property right under your nose and killed her being Amy, right? That's what you're told? To which Mr. Mullis responded, that's what I'm told, right?
Yes,
That's what I'm told.
And then the state asked Mr. Mullis, quote, and you know that's true now because you heard all the testimony in this case, right? To which Mr. Mullis said, yes. Did I read that correctly?
Yeah.
you did.
And the prosecutor next asked Mr. Mullis, you know that somebody took that corn rake and stabbed Amy in the back 2 or 3 times? To which Mr. Mullis said, yes. Did I read that correctly?
You did.
You now know this wasn't an accident. To which Mr. Mullis said, yes. Did I read that correctly?
Yes,
So we knew where we were at trial, as did Mr. Mullis based upon his testimony. Is that a fair understanding?
I believe it is.
And again, this is from if you know, this is from Mr. Mullis' sworn testimony while under oath, correct?
I believe it is.
So the worst part for Todd right there.
Now, speaking of preparation for testimony, you believed Tristan Mullis' testimony was essential to this case, didn't you?
I did.
Is it
I
fair to
agree.
say that you understood or Tristan to be an alibi for Mr. Mullis?
I did.
But shortly before trial, there was some break in Tristan Mullis' statements regarding how long Mr. Mullis was out of his sight, right?
That's correct.
Tell me a little bit about that. What was the concern?
We deposed Tristan at Al Parrish's law office. I believe Todd, I don't know if it was video or just audio, but he was listening in. And Tristan gave his testimony as to being in the barn with his mother and father, or his mother leaving, and him staying there, helping his dad, helping Todd clean things up and make repairs and such. He testified that he went into the kind of a work area at the front of the building, I believe to get a drink of water, and then went back in the building, the main part where the hogs would be, where he saw his dad again. And he gave an estimate of how long he would have not been able to see his dad. And it was quite short. I can't remember, 30 seconds or something, long enough to get a drink of water.
Now, is it fair to say your understanding was that Tristan's testimony stated that Mr. Mullis could not have murdered Amy Mullis because he wasn't out of Tristan Mullis' sight long enough to be able to commit the crime?
That's basically it, yes.
During the course of your investigation and prior to trial, however, Tristan Mullis' testimony changed, didn't it?
This has got to be really hard for Tristan.
Yes.
In fact, at his deposition, where he was represented by his own counsel, Tristan Mullis' testimony, for the first time while he was under oath, changed to say he couldn't recall a specific amount of time, right?
I believe so.
And that's ultimately the same sort of statement that he made at trial, if you remember, right?
I think so, yes.
Where he was also under oath, fair?
Yes.
Was this shocking to you when this occurred?
Yes. In some ways.
Because I believe, as you stated earlier, Tristan's testimony was critical in this case, yes?
Yes.
But you worked hard in order to try and convey that Tristan Mullis was still with his dad for the bulk of the time in that hog barn on the day Amy Mullis was murdered, right?
Yes, that was critical.
You asked him questions specifically about possibly the number of times that he would have gotten a drink of water or been out of the sight of his dad, right?
Yes.
You asked him about family dynamics between Mr. Mullis and Amy Mullis, didn't you?
I think so, yes.
And I believe you, correct me if I'm wrong, but was the goal to convey that Mr. Mullis and Amy Mullis were in a loving marriage and that they were a happy family?
Yes.
And you made that effort to convey this central theme with each of the state's witnesses who would potentially say something different, right?
I think so, yes.
And if you recall, during some of the witness testimony, you asked about showing they worked on their marriage through marriage counseling, for instance, right?
Yes.
That they took trips together to places like potentially the water park, fair?
Yes.
And that they were working on their marriage and being supportive. True?
True.
And I believe during your cross-examination, perhaps of Ms. Stainer, you mentioned the messages that specifically related to Amy Mullis calling Todd Mullis super dad or something to that extent, right?
Correct.
So at all times, you were working to convey not only a happy family approach, but also an approach that Mr. Mullis was a loving husband and father, right?
Yes.
He was trying to convey that Todd believed that, not that they actually were.
And at least by the end of trial, you had even worked on reviewing those messages to keep instances of potential violence or prejudicial acts like was present potentially in Ms. Stainer's messages, for instance, out of the jury's view.
Be right back.
True?
Yes.
And that's because you not only believed your client was innocent, but you were working to convey, a solid narrative of a united family. Is that fair?
Fair. Yes.
Looking to the trial when Mr. Mullis took the stand, do you recall asking him about the hunter safety course that his daughter was a part of?
I think we did. Yes.
And directing your attention to what I believe is trial transcript volume 4, which has been previously admitted as exhibit 350 in this case. And directing your attention to what is page 170. In scrolling down to the second half of the page, I believe, one moment. Looking at line 10 to line 14, you asked Mr. Mullis specifically if he had Googled about cheating wives or cheating spouses, didn't you?
I did.
And he denied it on the stand, didn't he?
Yes, he did.
And similarly, going down to the next two lines, Mr. Mullis denied knowing who would have looked that up, didn't he?
He did.
Looking down to the second half, beginning, I believe, at line 22 to 24, you also asked him about potential TV shows or channels that they would have watched as a family, right?
I did.
And potentially...
What did I just miss? Yes, I have. You were present when Deputy Hemeseth testified about certain searches about cheating spouses or cheating wives, that kind of thing. Did you do those searches? No, I did not. Do you know who did? I have no idea who looked that up. Did you and Amy ever discuss topics like that between the two of you? If it was a movie or something, we might have talked about a little bit of something like that, but not extensively, no. Did the two of you enjoy together history programs? I just wanted to see what I missed. Hey, Paul. He was testified that she could not be pushed into the rake due to the forward and sideways forces applies upon a push. The only way a push is possible is if he was able to push her down with no forward motion. Yes, that's how my understanding also.
You also asked him, going on from line 25 to the next page, about whether or not those searches could be follow-up searches on those shows, right?
That's correct.
Similarly, you evaluated or considered how they enjoyed history and of the Native Americans or Indian populations, right?
Yes.
And that there was evidence that they would watch not only shows about this, but potentially searches would align with these topics. Fair?
Fair.
Now, scrolling to what is page 174, beginning at line 14, you also asked Mr. Mullis to explain potentially some of the searches that related to starving to death, drowning, floating, those kinds of things, right?
I did.
And you allowed, or Mr. Mullis had the opportunity to say under oath that those topics were more normal or when considered in context, were not indicative that he committed a murder, right?
That's correct.
You also, looking to line 22 of page 174 of the transcript, you asked about chest wounds, gaping chest wounds, surviving in the cold, and other survival tactics or habits, didn't you?
I did.
To which Mr. Mullis answered, as we see mostly on page 175, that she was engaging in a hunter education program, an online thing, and that she was studying for it, and him and Amy Mullis were helping her review those educational course materials, right?
Yes.
And by her, I mean your daughter specifically. In this case, I'm sorry, Mr. Mullis' daughter specifically. We're late in the day, obviously.
Correct.
So you also asked about the hunter safety course materials specifically that have been, relevant not just to this proceeding, but what was the underlying Google searches too, right?
Yes.
In fact, when you crossed Deputy Himaseth, I believe, then Deputy Himaseth, on the Google searches specifically, you asked him to review things from K Jewelers and other things like Pinterest, for instance, too, didn't you?
I did.
And in your closing arguments, you mentioned specifically that these things suggested the iPad in question or the Google account itself were not just used by Mr. Mullis. Is that fair?
Yes, it is.
So you sought, is it fair to say, to categorize your work in this case that you attempted at every turn to mitigate the Google searches and the state's narrative of what they represented?
That's correct.
Taking you back again to a pretrial evaluation and how it impacted your trial tactics. You were asked on direct examination about whether or not you were looking for witnesses to testify to Mr. Mullis's good character. Do you recall that?
Yes.
But you were actively in contact with his family, weren't you?
Yes.
And individuals like Tom Krogman, for instance, who were mentioned, were also interviewed by DCI as well, weren't they?
Yes, they were.
And in those reports that you received and provided, in fact, to Mr. Mullis, you would have considered his role in the case. Is that fair?
Yes.
And that would be both as a potential person to help you investigate the case and as a potential person to testify on Mr. Mullis's behalf, right?
Yes.
But ultimately, as a matter of trial strategy, you chose not to call Mr. Krogman. Fair?
That's correct.
For that question, I think it's improper to ask if it's a matter of strategy when the witness hasn't
I hope so. I hope you're right.
testified that there was strategy in not calling Mr. Krogman.
Overruled. The answer will remain in the record.
So knowing how things impacted the case as it proceeded to trial too, you were asked several questions about the 911 call. Do you recall that?
Yes.
Now, in all cases, you actually listened to the 911 call before trial, didn't you?
I did.
And it was a part of your overall investigation and discovery into this case. Fair?
Yes.
Did you also speak with Mr. Mullis about the 911 call and what happened prior to Amy Mullis, leading up to Amy Mullis's death?
I'm sure we discussed it, yes.
To your understanding, is it fair to say Mr. Mullis conveyed to you that he didn't see how Amy Mullis died?
He said he didn't see how she was injured.
But he did tell you that he had pulled the corn rake out of Amy Mullis's back in order to be able to transport her to the hospital.
Can we get objection to foundation? When did Mr. Mullis say that to Mr. Firehome? What's the underlying context?
Mr. Gooden, would you like to place additional foundation?
Sure. Early in the case, did you ask Mr. Mullis what happened leading up to Amy Mullis's death?
Absolutely.
Would that be prior to you determining what course of action or case theory you wanted to proceed with to trial?
Paul, so I was asking, just for anybody who's listening and not reading chat, I was asking Paul if he happens to know about this guy that was that froze to death in Manchester, that was rumored to have an affair with Amy. It was in the email exchanges between Bob Saber and Jake, talking about that there was a rumor of a guy that was supposedly having an affair with Amy, who had been like run off the road or gotten in some accident, ended up freezing to death. And the rumor was that either the deputy she was having an affair with or Todd ran the guy off the road. And I'm like, okay, well, who the hell's that guy?
Yes.
Would that be early on, say, even before the trial information likely was filed in this case?
Probably so, yes.
So it was an early, is it fair to say that it was an early topic of discussion between you and Mr. Mullis?
Yes.
Having listened to the 911 call, that call ultimately came into evidence, correct?
It did.
Yeah, it's during his testimony when they're showing the email exchanges between him and his co-counsel, Bob. But we just read it probably, maybe 40 minutes ago or so.
And prior to Mr. Mullis' cross-examination, you had no reason to believe that the state would argue that the muttered statements under his breath that were claimed to be there were present, did you?
Had no idea.
But in response to those statements being alleged by the state, in your closing argument, you attempted to undermine the value or the claim that the statements about Amy Mullis being a cheating whore or telling her to, quote, die cheating whore was on the record. Is that fair?
Yes.
Oh, I believe it was, quote, go to hell cheating whore. I apologize for that statement. In those statements, you believe that there was heavy breathing, yes?
Yes.
In that you believed he was working to revive his wife. Is that a fair assessment?
Yes.
Your arguments at each time said that the state's asserted claims were false. Is that right?
That's correct.
Now, primarily as it relates to the heavy breathing, you were shown a potential transcript of a 911 call. Do you recall that?
Yes.
And in that transcript, when you read, do you recall reading from it?
When it was shown to me yesterday, yes.
And if you remember, in that transcript, they indicate there's things like heavy breathing, right?
It did.
So in fact, your claims or your arguments presented at closing were fairly consistent. Is that right?
I believe they were.
But is it your opinion that that ultimately came down to a weight or credibility determination for the jury?
I believe so.
And ultimately, after the trial came back and the jury found Mr. Mullis guilty of murdering Amy Mullis, you moved for a new trial and judgment, or to arrest judgment. Do you remember that?
Yes.
And you alleged that it was misconduct, in fact, to claim that those statements were made on the 911 call. Fair?
I believe it did, yes.
And so you sought to preserve that claim and also to ensure that Mr. Mullis had the fairest trial he could have, in your opinion, right?
Correct.
Now, in your more than 40 years of experience as a criminal defense attorney mostly, have you had transcripts of 911 calls be completed?
Certainly.
Have you done that yourself?
Yes.
Did you believe it to be necessary in this case?
No.
And to be fair, your arguments were to what was being said under someone's breath rather than overtly in the statements heard on the call. Is that a fair assessment?
Yes. It's my understanding that, and this was told to me by the prosecutor, that this muttering under and saying those terms was called in by someone watching on court TV, and that's how it came about.
So you weren't really assigning a lot of weight to these claims, is that fair?
That's very fair.
Did you ultimately review the Court of Appeals decision in this case?
I did.
And to your knowledge, did that opinion or ruling speak to the potential substance of the 911 call?
I think there was a footnote to that, about that, yes.
And if you recall, or correct me if I'm wrong, do you believe that that went, like you believed as well, to weight rather than a matter of fact, for instance?
Yes, I agree with that.
And that ultimately is how you proceeded in this case, right? You argued it in closing rather than sought to omit it from its admissible use.
Yes, that's correct.
And you attacked its use
He's
even after
doing
the
a good
trial.
job.
Yes.
Now, making very valid point. You argued this. You argued
Correct me
this.
if I'm
You
wrong, too.
argued
At the
this.
time that then Deputy Himeseth took the stand at trial, you even asked him about UTC time too, didn't you?
I did.
And in that line of questioning, you talked about cell phone extractions and the specific information at hand to the electronic devices like the iPad, right?
Correct.
And your course of action, is it fair to say that it was a strategic decision to proceed with attacking his credibility when you so that you could argue what he said didn't make sense?
Exactly.
And that is what you actually did in closing too, right?
Yes.
Mr. Fireholm, you've reviewed digital forensics information before, right?
I have.
You reviewed electronic discovery before too, right?
Yes.
And that would include even evidence from a Cellbrite phone dump. Yes?
Many times.
So you knew how to look at the records and electronic information provided to you as a part of the investigative file from the state shared during discovery, right?
I believe so.
And you talked through that discovery and those investigative files with Mr. Mullis, didn't you?
We did.
I don't think there's been any foundation that a conversation was ever held with Mr. Mullis regarding whatever piece of electronic evidence the state is trying to ask about.
Well, certainly there was testimony that counsel reviewed discovery materials with Mr. Mullis. Objection.
Did he answer?
Did he already answer the question?
During those periods of time, do you recall Mr. Mullis ever mentioning planting being an evaluation during, as to why he wouldn't have been able to make those searches?
That he was planting crops? Is
Yes.
that what you mean? Yeah, he talked about his schedule of long hours and working into the night.
But he never proffered it as a reason for why he didn't use the iPad, right?
Right.
And you didn't view it from the claim that that would have made it so he couldn't access the internet, true?
Correct. Right.
And in fact, when you asked him about it at trial, when he was on the stand, planting was not a reason that was provided as to why he couldn't have made those searches, right?
I think that's correct.
But still, he denied that he even conducted those searches, fair?
Yes.
Nobody asked him for the reason.
So at no point in time did Mr. Mullis, to the best of your recollection, did Mr. Mullis or his family ever provide that as a proffered reason why he could not have done the Google searches, fair?
I think that's fair, yes.
Looking to what's previously been admitted as Exhibit 233, which I know has been the subject of communication previously. Hold, please, I apologize.
Yeah, that's a hashtag farm life, hashtag farm accident. Brianna ends up impaled on a chicken.
One moment while we get that pulled up for you, Mr. Firehome. Do you see Exhibit 233 on the screen, Mr. Firehome?
I do.
Now, going to that last paragraph, I believe you had testified on direct examination that Mr. Mullis's inquiry about a possible quote unquote expert, you believed it to be just shotgunning. Am I right?
Yes.
And if I understood your testimony correctly, and please correct me if I'm wrong, this was because you and Mr. Mullis had evaluated different kinds of defenses and different ways to proceed at trial well before the trial ever took place, true?
That's true.
And this included what witnesses to call, including any potential need for an expert witness, possibly.
Yes, that's correct.
But looking at this page, if you don't mind scrolling to the top, thank you. On 233, do you see where it begins at number 18?
Yes.
So in this line, is it fair to say that this looks to be an incomplete list?
Yes.
And this exhibit actually doesn't have a date on this note specifically, does it?
I don't see one.
Do you even know when this note would have been sent to you?
I would have no idea.
How, other than the notation of legal up top, would you know that this was meant for you?
That would be my guess, that
Sent by
if he wrote
mail.
legal on there, that the jail would let him mail it or something. I don't know.
Well, knowing that, Mr. Firehome, I'd like to scroll and draw your attention to what I believe is page 2 of this exhibit.
Oh, have we seen this yet?
Does this page have a date either?
Oh, hey, it's actually
I
way
don't see
clearer. Okay, hold on. This is way clearer than it was. At this point, Travis said about all computer stuff being male related. She looked up more porn and stuff than I did. I guess it bails down to Tristan and his testimony. He is so critical. He is absolutely critical in this. I think that the Angie in the text to Terry could possibly be a gal Terry works with at Saint whatever. When Bob said lawsuit, I think this Angie was married, 40 plus years old, who had sex with a 17-year-old boy and would get fired or something. Oh, I know. I remember. I know what text message this is. And we were like, dang, Terry's just out here telling everybody's business. It's possible. It's possibly this gal, but not for sure. Either way, if Amy said some shit to Angie Burr, I don't know. This BS about me putting Taylor in snow plus other crap is such bullshit. It just irritates me. The Dr. Thompson stuff I'll leave to the lawyers. Hemisath or whatever acted like he didn't know what the augers were. Dr. Thompson didn't say much about anything except the bruise on Amy's chin. He said the knee scrapes and hand scrapes could be from chores that morning. My mind goes all over thinking of this, that the scrape on chin was upward or some shit. I don't know. The concrete where she was laying was an edge of concrete like this. Her head was here when we found her. I've speculated so much on this, it's getting old. Sounds like no one actually looked at clothing. Took pictures is all. Really, what do we have to do? Do we need more than Tristan or not? Seems like the state can get her family for witnesses. I guess I get Tristan, but he is with crooked people, but that shouldn't get him to say anything but the truth. That Hemisath kept saying that I was something. Hey, Connie.
So like before, you don't know when you would have received it, if at all. Is that fair?
That's correct.
And you don't know when it would have been sent or what it would have been about. Is that fair too?
That's fair.
Now, if you want to go ahead and review a little bit of this text, Mr. Firehelm, specifically the first 3 sentences, I'd like to ask you about the context of what this letter shows for you.
Okay.
Now, when you're going through this message, do you note that there's various individuals and different witnesses that the state called at trial?
Yes.
In conversations about the inclusion of, say, porn or the testimony of someone being critical, this case being Tristan, was important for not only trial purposes, but also for your case, right?
Yes.
Is it fair to say that you cannot with certainty say that this case or this letter was not received or, an insight after trial, for instance?
It could have been. I mean, I can't tell from just looking at it.
In fair point. So there's no way to know when this would have even been sent to you, if it was sent to you at all, right?
That's correct.
Now, moving to the next page of the same exhibit, what is page?
And Paul, did you see that Duden talks about multiple deputies?
Page 3, I believe. Focused on the screen. The first word on that screen, if I'm reading it correctly, is Lynn, correct?
Yes.
Now, I don't mean to, play games here, Mr. Firehelm, but is your name Lynn in any case?
Yep.
No.
Is this any indication that this letter was even sent to you?
No.
Doesn't look like it was.
So it's fair to say that it was actually not even a letter to you at all about the case, right?
That's quite possible.
And going to the next page, page 4, and I don't mean to beat a dead horse with this or anything, but this one's also addressed to Lynn, right?
It is.
Oh, this is a different one. Lynn, I hope you still have the sketches I made of the wound pattern and how the angle was when we found her. This is why the coat needs to be physically examined. I went on memory in those sketches. Even the pictures of her wounds don't tell me how deep one is versus the other, or the angle it went after penetration. Is this not the exact same letter? This is the exact same letter. I went in memory on those sketches, then the pictures are wounds. I'm like, I feel like I've already read this. This is the same letter.
So much of this document, if we'd like to proceed to the next page, for instance, or some of the others, would suggest that, again, I believe Lynn is the name shown in the top corner with a date actually on this copy, right?
Okay. Lynn, 8/29/19. By the way, her first affair was summer of 2013, 6 years ago now. Okay, so just heads up, her first affair that he knew about. Okay, depositions are over. I thought they went well, except for Travis Hemisath. Boy, what a dickhead. He is such a liar. He was saying the iPad was only mine and I was the only one that used it. And all this garbage. What crap. Everyone knew my password. Everyone used it. I had people stop and use it. How can I have been the only one on it when kids used it to look up stuff for hunter safety and several other things? We would sit on the couch and share the damn thing, for Christ's sake. Pass it around at night. Or lots of times would have someone sit down beside me. Amy looked up her email lots of times for feed orders and such. She knew exactly how to use it. Taylor and Tristan too. He repeatedly said I was the sole user and crap. I won't deny I used it most of the time, but to say I was the sole user is bullshit. Amy's email would come on it. If you hit Gmail in search, you would have a choice of mine or hers. So how could it be just me that used it? I was not the sole user. I was the majority user, but not the sole user. Boy, he made me so mad. Boy, he made me so mad. I could foam at the mouth. It was obvious he was lying about his lack of knowledge about her first affair. Oh, yeah. He umhummed around terrible. I don't know what that means. Around terrible when as bad as his when asked about, okay, he hummed around terrible when asked about his knowledge of it. Lee O'Lear didn't know a thing either. I don't know who that is, but it must be another deputy, I would assume. Boy, how convenient is that? Nobody know nothing of that, but they say I just had to know of Amy's affair. They act like they are dumb, and I was so knowledgeable. If the whole hospital knew, the cops knew too. They are all intertwined. They can lie their ass off. Nothing happens. Then they twist whatever I say. He umhummed.
Yes,
And that date is August 29th of 2019, right?
yes.
So this letter too was not addressed to you, right?
It appears not, yes.
So looking back on it, these ideas and insights from Mr. Mullis were not likely provided to you. Is that a fair assessment?
I don't remember seeing these, no.
So much of these ideas are either unbound in time or you're not the addressed recipient or intended recipient of this. Is that fair?
It's fair.
But drawing your attention to the other evidence in this case, and I don't know this specifically anymore, you discussed the DVR cameras or the security cameras on the Mullis farm too, didn't you?
Yes,
And that was on direct examination. You discussed how potentially those cameras would have gone out, right?
Yes.
The foundation, direct examination of who?
Your direct examination,
Of Mr. Mullis?
Mr. Fire.
Oh, sorry.
And just for clarity of the record, during the direct examination of you, Mr. Firehelm, shortly before, you discussed those DVR security camera recordings, right?
yes,
But that direct examination wasn't the first time you actually discussed those cameras, right?
correct.
At trial, do you recall that you alleged, like Mr. Mullis had told you previously, that potentially the cat had knocked it off or interrupted the signal? Is that fair?
Todd told me that, and so did his brother Mike, and maybe even Lynn too. I don't know.
So you investigated that evidence, didn't you?
Yes,
And you took not only Mr. Mullis at his word, but the support system that he had in place of his family too, right?
yes, and then I went and looked at it, and maybe I shouldn't volunteer. I'm sorry.
Well, I'll go ahead and ask the next
Ooh.
question. What is your insight on this issue specifically? What were you just going to say?
Objection.
I grew up on a farm with dairy cattle and cats and corn rakes and so forth. I was proud of myself as an attorney when I walked into the courtroom and talked to jurors and argued cases to have that practical experience. And when I walked into the shed and looked at the window and how it was situated, cats like to lay in the sun. I think that window faced west in the winter part of the year. All these things make sense. So that's what I meant. I'm sorry.
And again, you believed in your client's innocence through the trial, didn't you?
Very much so.
And you argued till the end of your representation that Mr. Mullis was not the one who had murdered Amy Mullis, right?
He did not believe he did
I
it.
did. That's correct.
But you knew what evidence would be essential to your case, didn't you?
I did.
And that critical piece of evidence was going to be Tristan Mullis's ability to provide an alibi for Todd Mullis at the time, correct?
Yes.
So when he changed his story specifically, or when he was potentially not going to be available to testify, you brought that to the judge's attention, didn't you?
I did.
Drawing your attention to what's previously been marked and admitted as State's Exhibit I. Let me know when you have it in front of you, Mr. Firehelm.
I have it right here on my desk.
For clarity of the record, Judge Bitter was the judge who presided over the case at the criminal trial level, is that right?
That's correct.
And so this email is dated August 13th of 2019, correct?
Yes.
And so this lengthy email with representatives of the state as well as for Tristan Mullis and your team too were included on this message, correct?
Yes.
Okay, so this is from Jake to, looks like the judge, his co-counsel, and the prosecutors. Judge Bitter, this email is to give you a heads up on developments in this case, which is currently set for trial on September 16th. I know that Al Parrish has informed you that he has been retained to represent Tristan Mullis, our client's 14-year-old son. Tristan is not listed as a witness by the state in the trial information, but the defense is planning on calling him as a witness. Tristan and his siblings are residing with the maternal grandmother and her husband, Ankeny, I think is how you say his name. The children have been placed there pursuant to a guardianship order from Polk County. Mr. Parrish informed Maureen and I in a phone conference yesterday that he had spoken to a counselor who has been seeing Tristan on a regular basis. Al indicated that she has had 12 sessions so far with him. Al also shared that this counselor recommended that Tristan not be called as a witness in either a trial or a deposition, at least not at this time. In a phone conference that I had this morning with our client, I informed him of these developments and asked him his position on whether or not he would agree to delay the trial to allow Tristan more time with his counselor, with the goal that he reach a point where he could testify, mainly because of the uncertainty of how long this process could take, that he is incarcerated awaiting trial. He was opposed to continuing the trial date. In a phone conference that I had with Al this morning, I shared our client's position with him. Al indicated that he would try to have something on file with the court asking for a protective order by the end of the week. He had asked Maureen and I yesterday if we would agree to have the counselor testify by phone in any hearing that might be necessary, which we agreed was okay. Why would the counselor be testifying? And the state did call Tristan. So.
And in this message specifically, you inquired about whether or not waiting for Tristan's potential issues addressed with his counselor to be addressed sufficiently so that he could testify at trial, right?
Yes.
And in order to ensure that he testified at trial, you floated the idea of a continuance to Mr. Mullis, didn't you?
I did. Sorry.
And in speaking with him about this, Mr. Mullis was adamant that trial should proceed as scheduled, wasn't he?
Yes.
Very much so.
And so he was opposed to continuing the trial date, and that was your position too, wasn't it?
He was opposed to it.
And at this time, trial was set for September, right?
Yes.
So in the interim between this email and when you began trial, you deposed Tristan Mullis, didn't you?
Yes.
And that was when his story changed, yes?
Yes.
But you proceeded to trial in September because Mr. Mullis did not wish to ask for a continuance, right?
That is correct.
So when we look at that September timeline, you were also asked potentially about whether or not he would have a fair jury that, at least my understanding would include potential farmers as well, correct?
That's how I understood it, yes.
But it was Mr. Mullis who wished for the case to proceed that month, right?
Yes.
In that month, I mean harvest season, true?
Yes.
And you were following the directions of your client, is that fair?
Yes.
So you proceeded to trial, but you had previously moved for a change of venue, right?
Yes.
Now, with about 40 years or more now of legal experience, is it fair to say that you know a judge would decide what venue to send it to rather than the parties specifically shopping for one?
Objection to the characterization of shopping in the state's question. It's inflammatory and prejudicial.
Would you like to revise your question, Mr. Duden?
Sure. Mr. Firehelm, in your experience as a lawyer with more than 40 years of practice under your belt, do attorneys get to choose what forum they go to when they move for a change of venue?
They don't have the final say, no.
Is it fair to say that a judge would make that ultimate decision?
Correct.
And in this case, the judge decided to move the venue to Dubuque County, right?
Yes.
And at that time, the concerns were ultimately revolved around whether or not Delaware County and Dubuque County were in the same media market, true?
That was one of the concerns, yes.
But you had asked prospective jurors when selecting a jury about potential exposure to media and their biases, didn't you?
I did.
So you sought to address those concerns to ensure your client would get a fair jury or a fair shake, right?
Yes.
And ultimately, when the jury was selected, did you have concerns about there being a fair cross-section or whether or not more representation of farmers or anything like that were going to be dispositive in this case?
No, I thought that this panel during voir dire was one of the more cooperative ones that I had encountered in trials, and I felt the cross-section was pretty good, actually.
So in your opinion, the selection of the jury was fairly good for the case that was at hand?
I did, yes.
And to your knowledge, at any point in time, was it conveyed to you that there was a concern about a lack of a fair jury or cross-section being selected?
I don't recall. Once we got going and the jury was picked, no, I don't recall any concerns by Bob, me, or Todd.
So is it fair to say that it wasn't really a concern for you in the Mullis
Thank you,
defense?
Connie.
I think that would be fair.
Thank you. And you're welcome.
You had spoken at length about Jerry Frazier while on direct examination in this case, correct?
I think so, yeah.
And specifically, at trial, were you pointing to Mr. Frazier as a potential person who would have motive to kill Amy Mullis as an option?
Yes.
You weren't necessarily saying that he was the murderer, were you?
No.
Were you?
You were in fact pointing to many other people who could potentially have reason to commit the act, right?
Yes.
And again, at all times, you were maintaining the narrative that Mr. Mullis did not commit the act in question, yes?
Correct.
That he didn't murder his wife.
That's right.
Now, my understanding, Mr. Fireholm, based upon your prior deposition testimony, is it fair to say you view the role of a defense attorney as one to sow doubt or reasonable doubt into a case rather than to prove the alternate versions of a crime, right?
Exactly.
That the burden is the state's to prove that a crime was committed, in this case a murder, not your burden to disprove it.
That's correct.
And so,
No, he disagreed with
in
them.
this case specifically, you were looking to provide potential other avenues that would sow that doubt in this case or help you secure a not guilty verdict for Mr. Mullis, right?
That is correct.
Mr. Fireholm, in your experience, would you say that you provided zealous advocacy for Mr. Mullis in this case?
Objection to
The vagueness of zealous advocacy, and it's inappropriate to ask Mr. Fireholm to judge his own performance.
Overruled.
Overruled.
Once again, I pride myself that, especially with the jury trials, that these situations for my clients are extremely stressful, important to them. In Todd's case, the most stressful, facing a life sentence. And I don't take that lightly. And I believe I did everything within the time frame that we had. That I did everything I could to obtain that verdict of acquittal.
I guess it's one of the last things that we need to talk about. Did you advise Mr. Mullis on his rights as it related to his ability to testify or not?
Yes.
Before trial, before he took the stand, did you work to talk through his testimony and help prepare?
Yes.
Didn't do
And
a good job.
in your professional opinion, or do you recall any instance specifically to which Mr. Mullis would have expressed concern or doubts about any of the process for him to take the stand?
I don't recall specifically. I mean, clients frequently say, you know, I don't want to blow it. I'm nervous, you know, those kinds of things. But I don't think Todd, you know, it wasn't like we had to drag him to the stand. And frankly, I thought he did a wonderful job.
Aww.
So just to confirm, you didn't encourage Todd Mullis to plead guilty.
Correct.
You didn't advise him that he should waive a jury trial.
No.
You didn't tell him not to testify on his own behalf or that he should one way or the other, really, did you?
No.
You didn't force him to take the stand, right?
No.
And you never encouraged him to forego an appeal, did you?
No.
To that end, was the choice to plead not guilty and maintain his innocence all the way through trial, did you help Mr. Mullis maintain that objective through trial?
As best I could, yes.
In the arguments that were chosen to pursue, the argument specifically was to pursue believing that this was a murder, right?
Yes.
And as a brief recap, you reviewed the discovery yourself with Mr. Sabers and Mr. Mullis, didn't you?
A number of times.
You deposed witnesses in this case to ensure you understood the different theories of the state's case as well as possible theories for your case, right?
Correct.
You always believed that your client was innocent and held out to the jury that Mr. Mullis did not commit the murder did not murder Amy Mullis, right?
I did.
And you worked to address the pitfalls and concerns of Google searches or electronic evidence, didn't you?
I did.
And you sought to make sure he was prepared and ready to proceed in maintaining his innocence and helping prove his innocence when he took the stand, right?
Yes.
So neat. Hi, Fish. Hi, Andy.
I don't have anything further. Thank you.
Can you redirect?
I do, Your Honor. Would it be possible to take a very short break just to get organized and then I'll be ready to go?
Probably just a real short break. I imagine we're running short on time, so.
Thank you.
Okay, we'll take just a few minutes.
I agree that he looks dejected, but I don't know if I agree that he seems remorseful. He thinks that he did a good job. He thinks that it was a murder, and he thinks that Todd didn't do it. Hi, Lana. So I get it. I get, like, this is like the big contention between a defendant waiving their right to a speedy trial versus having the time to be able to get all these experts on board, have them do all of this, all of their own downloads, extractions, experiments, and all the things experts need to do, yet still get to a speedy trial. This is, I mean, it's tough. It's tough. We're seeing it right now with Lori Vallow too. She does not want to waive her right to a speedy trial, but yet, the expert that she requested back at the beginning of January just got approved, and now she's not going to have time to actually get the information in. He seems dejected, but I don't think he seems. I don't feel like he's fallen on the sword. That's just my thought. I don't feel like he's fallen on this. I think he thinks he did a good job. I disagree with him. I do not think that he did a good job. Oh, Lana, you didn't have to do that. Thank you, honey. It's your birthday week. So I just don't know. Even if you don't have time, somebody needs to ask this. Jake, did you give the reports to anybody to even look at? Maybe you didn't bring the expert on. You didn't actually. Yeah, see, that's what I want to see, Paul. I want to see the rest of the depositions that she has. That's what I want to see. And the time, yeah, and that's another great point too, Gray Space. The time constraint doesn't have anything to do with just not objecting to shit at trial or making sure that your motion in limine actually had a ruling on it before you actually went to trial. It's true. True. What are these? Let me see what these are. These are, I think Are these the depositions or no, Paul? Let me see. No, this is not that. All right, I'll have to look at. I'll look at these later.
Please be seated.
Oh, okay, I got you. You don't have those yet, then, right, Paul?
Ms. Nichols Cook, are you ready to pick back up?
Yes, thank you, Your
All
Honor.
right, you may proceed when you're ready.
Mr. Firehome, you were asked on cross about an email that indicated Todd was stressed and having trouble reviewing discovery. Do you recall that?
I do.
To your knowledge, had Mr. Mullis ever been incarcerated before? And to your knowledge, was this the first time that Mr. Mullis was learning about Amy's affair with Jerry Frazier in the discovery?
I'm not certain that's true.
Did you do any investigation to figure out if that was true?
I think Turnbuck
We
told
talked
me.
about it. But what I'm being careful here is I'm not certain that Todd told us that he knew about it before this discovery material was reviewed or not.
Would you agree, though, it'd be upsetting?
Certainly,
Yeah.
certainly.
I want to reference States Exhibit F, the email from April. I think you have that.
I do.
And in that email, it says, we need to have an expert take a look at the autopsy. Is that what it means?
That's what it says, yes.
But you never did do that.
No,
Do you recall a note that was passed to you after your opening statement that said WTF on it?
Ooh.
I eventually saw it. I'm not sure when.
Did you understand that to mean that your client didn't know what you were going to say in opening?
I'm not sure what was intended.
Did you talk to your client about it?
What the fuck?
No, I don't think so.
Never even bothered to
And
talk to him
you
about
would
it.
agree with me that Mr. Mullis never told you he believed it was a murder?
I'm not going to say he said those words, no.
You talked on cross about it was the state's burden to prove beyond a reasonable doubt that a crime had occurred. Do you remember that?
Yes,
And would you agree that in your opening you conceded a crime occurred?
Yes.
yes,
And would you agree that Todd always maintained it was an accident?
he always maintained that that was possible, yes.
And in your deposition, you testified that Todd never agreed with you that it was murder. Do you remember that?
I think that's what I said, yes.
You testified on cross that Tristan, you considered him to be an essential witness because he was an alibi. Do you remember that?
Yes,
Tristan's testimony was only essential if you believed Amy's death was the result of a homicide, right?
yes,
Mm-hmm.
You were asked about the change in Tristan's testimony in his deposition. Do you remember that?
yes.
Did you do anything to present all of the prior statements Tristan had made before his dad was arrested that indicated he was with his dad the whole morning?
I think we did, yes.
You were asked about the Google searches and the electronic evidence. Do you recall that?
Yes,
And you've also told us that you prefer paper over electronic documents, right?
as far as maintaining the files and exhibits and discovery, yes.
And I've showed you several things today that come from electronic discovery that you didn't have before.
Yes,
I want to go briefly back to Exhibit 233 that the state showed you and asked you about as well. Do you recall testifying in your deposition that this was Todd's handwriting and a letter you received from him?
No, I don't recall those specifics, no.
Let me find the page for you here. Elena, you put it in the end. Okay, Mr. Firehelm, you have a copy of your deposition in front of you, right?
Would anybody here be surprised if I told you that this was the attorney who was on I'm Not a Cat video? I'm here. I'm live, Judge. I'm not a cat. Like that's the epitome of how I feel about Jake.
I do.
And for the record, it's our Exhibit 323. If you could look at page 19 and start at line 22. And read through page 20, lines 8 through 13.
So on brand. No, I don't
Read
think it
to
is.
how far?
Page 20,
But it
lines 8
wouldn't
through
surprise me
13.
if it was. That's the point. Do you really use headphones? That's hilarious. That's the best. That's one of my favorite clips ever in life.
Okay, I've done.
And does that discuss letters from Todd?
Yes.
If you would go back to looking at 233, and we'll scroll to the third page.
Right.
Do you see a date there at the top?
What?
I'm sorry, it's not the third page, it is the fifth page. My apologies.
Yes, I see that date, August 29th.
2019.
Yes, correct.
This would have been about a month before Mr. Mullis's trial.
About 3 weeks, yeah.
And you testified earlier that you spoke with Todd's sister Lynn a lot during your representation of Todd.
I wonder if Travis knows him.
Yeah, quite a bit, yes.
And that Lynn would give you information as well.
Oh, Lynn gave him the letter.
Yeah,
And that she would call you or email you and say Todd needed to see you or talk to you.
that was common, yes.
If you go down to page 10 of 233.
Why would Todd need to tell his sister that he needed to talk to his attorney? Why would he just contact his attorney? That's weird, no? Was he not like answering the phone? Ooh, there was more to the letter.
Of
Go
233.
back and see if we can
That was
get it.
common, yes.
If you go down to page 10
Page 10? Jeez,
of
okay.
233.
Oh, it's gonna be too blurry. Ugh.
Do you see the handwriting in the middle of the page at an angle?
Probably.
Yeah.
What does it say?
Lawyers first, then Lynn or Mike.
So is it entirely possible that
Lawyers first, then Lynn or Mike. So give it to the lawyers and they'll give it to Lynn or Mike.
this letter was sent to you?
Objection, speculation.
So is
First, then Lynn or Mike.
Cindy?
So is it entirely possible that this letter was sent to you?
Objection, speculation.
Overruled. The witness can answer if he's able.
Anything's possible, but I just don't think so.
Oh, you have Mullis family? Are they related closely?
But you were representing Mr. Mullis August 19th, 2019. So you would have been one of those lawyers referenced on page 10.
I assume so, yeah.
Do you remember signing an affidavit regarding your representation in this case?
Yeah, I remember signing one, yes.
It's Exhibit 224. We can show it to you. I don't know if you have it.
I think I have it.
Oh, that's crazy, Cindy.
Can
That's
you see the one on the
crazy.
screen?
Yeah, I just found it. I have it in front of me.
Okay. You were asked about the 911 call that was played for Todd on his cross-examination.
Yes.
And in this affidavit, can you read paragraph number 10?
Objection.
I did not.
That's not an evidence, Your Honor. This is not an admitted exhibit and consistent with the court.
Oh, here, let's see. Okay, so this is Mr. Jake's affidavit. Number 1, I have been a licensed attorney for approximately 43 years. Number 2, in or around March 2019, I was retained by Todd Mullis following a charge against him on a first-degree murder in connection with the death of his wife, Amy Mullis. My representation of Todd continued throughout a jury trial held on September 16th through September 23rd of 2019 with attorney Robert Sabers, who acted as second chair co-counsel. I also filed a post-trial motion. At the time of this trial, I had been lead counsel in approximately 7 first-degree. That was it. In 7 first-degree. Okay. The defense of this, number 4, the defense of this case included forensic pathology and law enforcement investigation. Number 5, I did not consider the accident theory, i.e. that Amy had accidentally sustained her injuries by falling onto the corn rake, to be a realistic possibility because I grew up on a farm with personal experience using a corn rake, and I did not think this was a likely scenario, taking into account clothes that Amy was wearing and the nature / extent of her wounds. Clothes that he never actually went and looked at. Just FYI. Kathy. That's fucking hilarious. Oh, God. And he was wearing in the nature extent of her wounds. Number 6, I did not personally consult with any experts in this matter. Number 7, co-counsel Bob Sabers passed me notes during trial with suggested questions for cross-examinations. Number 8, I did not personally review or examine the physical evidence in this case, including the clothing Amy Mullis wore on the day of her injuries. Number 9, prior to trial, we did not hire or consult with a private investigator, although I discussed the need to do so with co-counsel. So that blows the state right out of the water right there when he was trying to say, like, ooh, you chose a different path for your, your strategy. You went with a private investigator versus the expert. No, didn't go with an expert or a private investigator. Number 10, I did not request a mistrial following the state's suggestion. Todd referred to Amy as a cheating whore during the 911 call. I should have moved for a mistrial.
Court's order on day 1, affidavits have not and likely would not be admitted.
Your Honor, I was asking the witness to read it to himself. I apologize. That wasn't clear.
Okay, so for now, at least, the objection will be overruled.
Let me know when you've had a chance to read paragraph 10.
I have.
And do you recall me asking you earlier about whether you asked for move for a mistrial after that 911 call and the arguments were made by the prosecutor?
Yeah, I think you did.
And with all of the decades of experience, have you moved for a mistrial before?
Yes.
And do you agree that you could have and should have in this case?
In hindsight, I could have.
And in fact, you've said before you should have.
Right.
He's not a farmer.
You were asked about conducting depositions leading up to this trial. Do you remember that on cross?
Yes.
You testified earlier that you didn't conduct any research or investigation before those depositions. Is that still true?
Research as to what?
Well, to prepare for depositions regarding the electronic evidence or any other topic?
Who'd you consult with?
I reviewed the discovery that had been produced.
Other than reading police reports, you didn't do anything else. Is that correct?
Ooh.
Talked to Todd, talked to Bob, Lynn, Mike.
None of those guys have any answers.
And you didn't consult any experts to help you understand the evidence?
Objection
That
to
is-
be considered within the scope of the direct and the cross, Your Honor.
Overruled. If there is an answer, it will remain in the record. Okay. I don't think there was. Mr. Firehelm, do you remember the question?
I started to say it. What my answer was, that's correct.
You were asked on cross about complying with Todd Mullis's wish to not continue his trial. Do you remember that?
Yes.
Do you disagree that you didn't comply with anything else that Todd asked you to do as far as consulting an expert regarding whether her injuries were the result of an accident?
Objection argumentative in the state's testimony.
Overruled.
I don't do.
What?
My response to Todd's references to getting experts as ignoring him, or whether I complied with him. I think I've explained that before, how I viewed that.
It's not up to Todd.
You were asked several questions on cross about investigating issues. Are there actions you took that we have not discussed today?
Good question.
The only thing I can think of is in some cases, as a member of the Iowa Association for Justice in the criminal group of that organization, we have a pretty active listserv. So once in a while, an issue will come up, and rarely will the attorneys, and I'm one of them, will we give the name of a case or a client's name or something. But if it's an evidentiary issue or something like that, I think I probably did that in this case. I don't remember specifics, but that's one thing other than what we've talked about, I guess.
Thank you. I wanted to follow up on the testimony by Deputy Himsath at trial about the timing of those Google searches. Do you recall that?
Yeah, kind of.
Do you know why you didn't impeach him? That he had the calculations of the timing of those messages wrong?
I guess I thought we did to some extent. I don't remember exactly how the record reads.
Do you understand how to do a UTC calculation?
Yeah.
So if you didn't impeach him, you don't have a reason for that?
I guess whatever I did, I did. I'll just stand on the record.
You were asked on cross about the hunter safety certificates and guide and the questions you asked Todd Mullis. Do you remember that?
Yes.
Did you obtain a copy of that guide and compare it to the Google searches?
I don't believe so.
Did you talk with Todd's daughter or Tristan about what types of searches they might have done?
I don't think so.
That's a
Did you
big
only
for me.
put Todd on to explain that, to testify?
Yes.
Could have asked Tristan that. He just didn't.
You were asked about your email in April where you believed it was murder based on your review.
Yes.
And you were asked about working with an accident reconstructionist or a biomechanical engineer, I think.
Yes.
Have you worked with an accident reconstructionist before?
Yes.
But you did not do that in this case.
Yes. That's correct.
Do you recall being asked in your deposition whether you had the consent of Todd Mullis to concede it was a homicide prior to making your opening statement?
I don't recall specifically, no.
If we could go to your deposition, page 22, I think, or is that 23? Oh, line 23, page 22, line 23.
Yeah, I see that.
And your answer to that question about whether Todd consented was no. Not like I'm okay with that, no.
That's what it says.
So any testimony you gave today that you think Todd knew is different than your testimony from your deposition?
Well, if that's the way you interpret it, that's not what I meant. What I testified to today, I think, is that I felt that Todd had acquiesced in that concept.
So Mr. Firehelm, did you understand Todd to always maintain that it was an accident that injured Amy?
I'd have to answer that yes. Yes, but I guess.
But he never told me he didn't think it was a murder.
But you did not present that theory or investigate that theory for him. Is that accurate?
Didn't present it. I'm not saying we didn't investigate it.
You didn't
Did you
investigate
talk to any experts about it?
Objection,
No.
Your Honor. This is asking answered and cumulative to the record at this point.
Objection is overruled. The answer will remain in the record.
Your Honor.
Oh, wait, any redirect?
I'm sorry, Your Honor, I have one more question. May I go back?
You may.
Mr. Firehelm, in your opening statement, you told the jury that Todd's prior statements to law enforcement were wrong. Do you remember that?
If that's what I said, yes.
And then you put your client on to testify in your defense without any corroboration.
Yes.
Objection, Your Honor, from just clarification of the record purposes, I believe that's necessary to say your
No,
defense, I
well,
believe, should be clarified if possible to Mr. Mullis's defense.
But we do think that I believe that there's a deposition that was submitted from Tristan. We just don't have access to it yet.
Right, certainly that's the way the court understood it.
Thank you, Your Honor.
Do you want me to repeat or rephrase the question?
Please.
If the transcripts show in your opening statement that you told the jury Todd was wrong when he talked to law enforcement, and then you put Todd on in the defense in chief and expected the jury to believe him, that was what you did?
Yes, that is what you did.
What I told the jury is that Todd told law enforcement that she fell, that it was an accident. That's what he initially thought. He testified on cross-examination that it was a murder. So I'm not sure what you mean, I guess.
I'll move on and follow up on that, and I know I have to be done. Todd's testimony at trial is reflected in the transcripts, right?
Yes.
And so if the prosecutor asked him, based on what you've heard at this trial, do you now know it's murder? Would that be different than Todd's belief that it was murder versus an accident?
I can't say.
Okay, and Mr. Mullis wasn't qualified to review the autopsy report or do an accident
Somebody
reconstruction
asked if he is.
to have his own belief.
I'm sorry, what was your objection? I didn't hear it.
Well, one, this is irrelevant and it's not facts in contest, so it's immaterial and far more prejudicial than probative because certainly no one is contesting that.
Oh. I think we're getting a little far afield here. Sustained.
Ooh, that's not good.
No further questions?
Any redirect?
Briefly, Your Honor, permission to share the screen.
You may.
Perfect. Drawing your attention to what has been marked previously as Exhibit 350, and specifically drawing your attention to page 75, line 25. Do you see that, Mr. Firehelm?
350?
Yes.
So it says, I want to talk to you about some of the times that you're given. What's UTC mean on this printout? That was your question to Deputy Himmelsath, wasn't it?
Yes.
To which he responded Central Standard Time, right?
Yes.
And you just say, if the internet tells you you're wrong, would you disagree? And he said, can you ask that again? I guess I've never had the internet tell me I'm wrong, which I believe is a joke or also just maybe in jest. In either way,
it wasn't. He
have
was
you
serious.
ever researched that UTC is the successor to Greenwich Meridian Time, GMT? To which he responded, okay, I've never searched that, no, right?
Yes.
Now continuing down through page 77, line 5, let me know when you've reviewed it or if you need it slowed down.
He was dead serious.
Have you reviewed it, Mr. Firehelm?
I see it.
And in this case, so you did actually impeach Deputy Himmelsath on UTC time specifically, right?
I thought I had.
And so the record would speak on that point. Would you agree?
Yes.
Did you author your affidavit that was referenced earlier?
Yes.
In the time, it was not authored with the benefit of having your file, right?
That's correct.
Nor when your deposition occurred, did you have the benefit of your file. True?
That's correct.
Because you had given it to ensure that the successor attorneys representing Mr. Mullis could continue their representation in the underlying criminal case and on appeal, right?
That is correct.
Knowing now, with the benefit of the records and the transcripts before you, is your testimony today true and accurate to the best of your knowledge?
Yes.
I don't have anything further, Your Honor.
Anything further, Ms. Nichols-Cook?
Just, Mr. Firehelm, do you know if you've ever seen the cell phone extraction data from Tristan Mullis's phone?
I don't think so. No.
And then just for purposes of the record, do we need to identify if there's someone in the room with Mr. Firehelm or not?
We can. Mr. Firehelm, is there anyone in the room with you? I guess I'm not sure if you're in your office or elsewhere.
I got the door locked and I've been here by myself all afternoon.
Thank you. I guess back to you, Mr. Duden. There was another question from
None
your
needed,
side.
Your
So.
Honor.
You're done?
Yes.
Okay. All right, Mr. Firehelm, it sounds like that should conclude your testimony. Thank you. I'll go ahead and end the Zoom at this time.
Thank you.
That was interesting. Right, if they send it to my cat. Nobody should be getting that guy's birthday. I'll just say that.
Okay, it is just about exactly 4:30, so it looks like this will be our ending point for the day. We'll plan on picking back up at 9 a.m. on Monday. Counsel, if you'd like to stop back in chambers, obviously we can touch base about the schedule.
All right, let's take a look
Anything
at
else we need to
Monday.
do on
Let's
the
take a look at
record
Monday.
before we?
Let's take a look at this day. I want to see if they have any big gaps, because like you guys know, I haven't watched any of this. So I just want to make sure that, like we had on this day, is there like a huge gap in no testimony? It doesn't look like it. It looks like we've got a full day. Because if there was like a huge gap, then I'm wondering how much is actually. I was like, should we just keep going today and finish it? Okay, that's like a good hour. Nah, we'll have to do it. We'll have to go back. We'll be back Monday too. Yeah, I know we're at 2 hours of testimony. Then we get a break. We're back for another. That's a pretty long break right there. Back for another hour. So we're at like 3 hours of testimony. And then I think we get to like closing statements and no more witnesses. Okay, so I think we'll do one more day. We'll do one more day for day 6, so we'll come back Monday and do that. Hi, Amanda. Unlock the door. You are free, sir. Hey, Debs. Just popping in to say hi. Lots to catch up on. Hope y'all are good. What's up, streets? And people, different people, I don't know, but they definitely are in a group chat together at least. They may be different people. Who? What are we talking about? Hold on. Missed what we said. Oh, he's a legit. Yeah, he absolutely is legit. That was actually just his regular Zoom. Hey, Snappy. Look at you guys all popping in. All right, well, we're gonna wrap this one up. Did you enjoy Stacy last night? I did. I did enjoy Stacy last night. I thought that they, the three of them, Bob, Allie, and Andrea, all did a great job with the questions. I think that there was a few things that I was hoping they could dig more into, but I think Stacy was on a time constraint. So, but for the time that they had, I thought it was a great interview. So, I mean, it's one that you can probably take some info away from, for sure. So, and then somebody in chat said that Lana is having Andrea on tonight. Let's see. So that's 5 o'clock my time. So that is, put my notification on. I will give you guys that link. Delphi, Idaho 4, and Karen Reed. So they're just going to have a good old chit chat. So I'll drop you guys that link too. Here. So that's, Andrea is going to be on with Lana tonight. And then we'll be back Monday for day 6 of, you guys just be nice to each other. It kind of just is what it is. People agree, people don't agree. It just is what it is. But yeah, Monday we'll be back. We've got gymnastics competition. Well, Kaylee has gymnastics competition this weekend. I don't know if I'll be doing another live tonight. I really haven't. I have other lives I need to get done. We'll see. It's just not enough time in the day. I need an adult for the Karen Reed case right now, and Bettero is busy and can't go on a stream tonight. Okay, well, definitely go watch Andrea then. They're going to be talking Delphi, Idaho 4, and Karen Reed. So bada bing, bada boom. Yeah. So, okay, I appreciate you guys spending the day with me. We are almost done with Todd Mullis post-conviction relief. It'll take us right into a good time for the fact that both sides' briefs in this case are due to her by April 8th, and then she will be making a decision on whether he's going to get a new trial or not. So all of you guys will at least be up to speed with everything that happened in his first trial in 2019, that he did an interlocutory appeal in 2019. He did a Iowa Supreme Court appeal in 2020, both denied, and then we are now at this post-conviction relief. So I will see you guys back here Monday morning to finish Todd Mullis. If I have time, which I'm hoping I can squeeze some in, I want to do an Idaho live. I will probably, I don't know if I will be live watching Lana or if I will have to be on replay because that's right around dinner time, but we'll see. So anyway, love you guys. Thank you guys for spending your time here with me today and watching this and actually caring about justice, actual justice, and making sure that the right person is behind bars for crimes that are actually committed and not freak accidents on the farm during farm life. Love you all. Enjoy the rest of your Friday. If I don't see you sooner, I will see you Monday. Bye.
Do you dare to fall?